My lord, may be permitted for correction of the order.
Or may I permit to mention for upgradation of 4 identical matters where lands already been used without initiating the acquisition proceeding.
Is it in the monthly list?
Yes, ma'am.
While the private respondent construction structure house, Tata house, upon which they have a block to
Give the number, give the number. What is your urgency, sir?
The private government sanctioned the toilets sanction money, but private respondent include the full letter.
Give the number.
Well, style indulgence to mention one matter.
Yes. It's in the monthly list.
But similar table for upgradation for monthly list, my lord.
Loss, monthly list matter
Yes.
going for arbitration loss.
Contempt.
My lord, I am mentioning, my lord. My lord, petitioner's irrigation equipment have been, my lord, dropped by the private respondents by the entire, my lord, Vastu land, my lord, entrance portion. My lord, this is, my lord, this was running in the supplementary list on Thursday. Thereafter, neither it has come in the combined monthly list today, and thereafter it has not appeared.
Monthly তে appear করছে এটা. It's appearing in the monthly
But
list
appearing
today.
in the supplementary list.
Is it appearing in the monthly list today?
Today it is not appeared.
Then do not mention. I have segregated the monthly list from the supplementary list. Today only monthly list matters will appear. From tomorrow onwards, the supplementary list matters as they are will appear.
They are.
So if they're in the supplementary list, do not mention.
My lord,
It will automatically appear.
my lord, I am humbly pray, my lord, let, it was running as item number 150.
Sir, I have told you, please do not mention supplementary list matters. They'll automatically appear.
Loss in name,
May I have the style indulgence to mention one matter for extension of E3 model. Because we has passed the order on 25th of July. E3 model is expiring on today, while of 4th September.
Yes.
My lord, it's appearing as item number 886 in the monthly list. My lord, I am bringing it
The extension of interim order.
tomorrow, my lord.
My lord, item number 200-21.
Permitted to mention the matter 707 in the monthly list for upgradation. Urgency is that the demolition process was started by the sub-divisional magistrate. Before final order, the proceeding was dropped because of the without direction of the Honorable High Court. They cannot prosecute the demolition process.
Give the number, let me see.
My lord, item number 202 of monthly list, my lord, I am paying for upgradation, my lord. My lord, the respondent authority, my lord, by encroaching my land, my lord, started the construction of burial ground boundary wall, my lord.
Give the
My
number.
lord, 399 of monthly list, my lord, upgradation, my lord, your petitioner is a senior citizen aged about 80 years. My lord, after 40 years of fight, my lord, pursuant to this honorable court's order, my lord, Refugee Relief Rehabilitation Center department, my lord, issued gift it. But my lord, dark number is wrong, name is wrong, everything is wrong. I am unable to mutate my property, my lord. Kindly, my lord, accept.
May I permit to mention one matter for inclusion. Upon notice, I mentioned matter before your lordship. If urgency in the matter involved is the name of the respondent in the RS record. And the petitioner and the respondent are in a family relationship. And due to the injunction of the passed by this honorable court, the respondent is not getting her compensation for her acquired land. In the present circumstance,
Injunction order passed by this court?
no, my lord.
Which court?
Right now,
There cannot be an injunction order by this court in these matters.
but my lord, it will come, my lord has the determination.
What is your prayer in the writ petition?
My lord, because until and unless the matter is heard out, she will not get the money, and she is in the need of money due to her ailment.
Everyone is in need of money, madam. Give the number. Let me see.
Lord, may I be permitted to mention?
What content? Upgradation from monthly.
Why upgradation?
Upgradation 853 item number in monthly.
What is your urgency? No urgency. Give the numbers.
My
My lord, may I be permitted to mention one matter, my lord? My lord,
Yes.
May I allow to mention one matter, my lord, which is item number 276 of your monthly list, my lord. Petitioner's land has been acquired, but no award has been passed till date, my lord. I'm praying for.
Give the number.
on review application, My lord, contempt application is
Oh.
fixed. Yes, my lord, contempt application is fixed on 6th, my lord.
They put the other side on notice
Yes, my lord.
My lord.
My lord, may I be,
along with the contempt application, review application.
6 तारीख है contempt.
I have signed the losses, my lord. This matter.
Contempt and number koi.
Losses, my highest time.
Contempt and number.
My lord, that we have to
On-
have Asansol land.
Regarding
Review
That
to
we have to have Asansol land. Nagarasuda village.
The contempt number koi.
Dasgupta also appeared.
Mother file and number kothay.
Seeking the direction of my lord, the matter will appear in the month of November. Thereafter, my lord, this matter is
Amit
not
lord,
appearing.
Amit
Lord,
these
so
are-
month of November,
Yes, last year.
last year November.
Yes.
Give the number, let me see.
My lord, kindly consider.
It's a hearing matter.
This hearing matter.
Give the number, let me see.
My lord,
Lord,
everything
may I
has
be-
been exchanged.
may I be permitted to
May I
mention?
permitted to mention? My lord, everything.
Give the number, let me see. Yes.
Permitted to mention 3 identical matters, your lordship, under the head motion. Here, my lord, the petitioner's land were taken up for construction of metro railway, and the lands are already being utilized. The matter was once heard before his lordship, Justice Vivek Chaudhary on 7th of August 2023. Lordship was pleased to appeal the matter and granted liberty to the petitioner. Mention the matter before the regular bench, which is of your lordship's bench, honorable bench, and the respondents were directed to file a report in the form of an affidavit. 3 weeks has already over on 1st of September.
Report has not been filed.
Report has not been filed, hence I am.
Give the number, let
There
me
is
see.
some urgency in the-
Yes, Mr. Das.
My lord,
Give the number, give the number.
my lord, may I need to mention one matter?
What are-
That matter was appeared in,
That would be.
that matter was appeared in the list on 30th August 2023. But today is not appeared, great urgency is due during the pendency of the appeal of the 10-4 of the Highways Act.
It is appearing in the supplementary list. It was appearing in the supplementary list.
It was appeared in the 30th August 2000.
It will again appear in the supplementary list.
Urgency is this.
Today only the monthly list is being taken up.
Yes, my lord, kindly take it up to tomorrow, my lord.
So please give, if the matter does not appear in the list tomorrow, please mention.
It's only great urgency is this.
Please do not mention today, sir. Your matter is in the supplementary list. So tomorrow the supplementary list will be taken up again. Today only the monthly list is being taken up. I have segregated the supplementary list and the monthly list, so that supplementary list matters do not again appear in the monthly list. Yes. So today only monthly list is being taken up. From tomorrow, the usual supplementary list will come again. So if it is still not appearing, please mention.
my lord, may I be permitted to mention one matter? My
Express it clear,
lord, for
Akshay.
include,
Yes.
Just to mention one matter, your lordship, this is a matter of restoration application. This is the third time I am mentioning. But it
It's
is
not
coming
appearing.
in
Give the number. Give the number. The restoration.
Lordship, may I be
lord,
permitted?
may I be permitted to mention?
permitted to
Lord, for
mention?
inclusion.
Lordship, may I permitted to mention motion matter, Lordship.
It is in the monthly list.
Yes, Lordship.
Yes, or the supplementary list.
No, monthly list, no, Lordship.
Yes.
It is not in monthly list, Lordship.
Lordship, may I be
If it
permitted?
is not in the monthly list, do not mention, please.
Lord,
It
may I be
will appear in the supplementary list, I'm sure.
Lordship, may I be permitted to mention?
Lord, for inclusion.
Lordship, this matter pertains to unauthorized construction. Despite several representation, no steps have been
Appearing in
appearing in motion, Lordship.
which list?
Monthly.
A monthly list.
Monthly list. Give the number.
My lord, may I be permitted for inclusion?
Give the number. It's in the monthly list.
Lord, for inclusion, my lord. It is not appearing, my lord, in the monthly list, my lord. It was last appeared, my lord. My lord, 1 week back in the
If it is not
supplementary
in
list.
the monthly list, do not mention today. Come back tomorrow.
Lastly appeared
I would
1
like to
week.
see what comes in the supplementary list tomorrow. Yes, after that mention.
My lord, may I be permitted to mention 2 matters of the monthly list? This is relates to unauthorized enforcement.
Give the
May I,
number.
Lordship, kindly leave to mention?
Next stamp paper, my lord, listed in the monthly list, my lord.
Forged stamp.
My-
May I kindly mention, Lordship, what matter, Lordship?
Item number
Application, Lordship.
Item number label.
Monthly list, Lordship. Lordship, urgency is that, Lordship, without acquisition, petitioner land using by the respondent by constructed water reservoir. Thereafter, respondent made a representation before the authority that was not considered. We come before the learned court, and learned court directed as per direction of the learned court, wherein was held, Lordship, that was reject the prayer of the petitioner, Lordship, and thereafter, Lordship,
This
petitioner come-
resolution has been filed.
petitioner come before your lordship, and your lordship directed month of January, lordship filed the opposition and reply. Still date they are not filed opposition and reply. Appearing in the supplement.
Give the number, let me see.
I have, Lordship, kindly leave to mention
Sufficient matters have been taken up today.
Matlab,
Some
monthly
things mentioned tomorrow, not today. No more, no more.
Matlab, for monthly list,
tomorrow,
monthly
tomorrow.
list मतलब supplement. For monthly list मतलब supplementary. मतलब earlier occasion मतलब matter रहती है.
Recalling application, give the number.
Lordship, if you permit me.
Please come back tomorrow, sir. Please come back tomorrow. Sufficient matters have been taken up today. Please come back. Tomorrow, sir.
You already mentioned twice.
What is it? What are you asking for?
This is a contempt matter.
Yes,
Contempt matter.
contempt matter. Give the number. Yes, call the raised list, please. Item 1.
My lord, I am for the petition.
May I be permitted to mention the matter?
No, not at all. Mentioning is over. Item number 1.
I complied the order, my lord. Today, my lord, I have take over the office to my lord. Spontaneously stated, my lord. Only, my lord, the writ petitioner was not called for without the presence of that my lord, order was passed for that is my lord. The contempt was issued, personal affairs was issued, my lord.
Yes, you are appearing for the applicant petitioner complied.
Now, my lord, this was, my lord, on 7th of August 2023.
Yes.
After the issuance of, my lord, the notice, my lord, on 28th, as it appear, I have just handed over, my lord, my learned friend, my lord, handed over the, my lord, compliance report, so cause my lord, kindly takes it up some other day, my lord,
You
so
want
that,
to go through the report and.
yes, yes, otherwise, my lord, it is quite difficult, my lord.
Very well. The alleged contemner is present before this court. Paragraph affidavit of. This is the affidavit of show cause.
Yes, ma'am.
And the contempt?
My lord, in that, my lord, I have complied that.
Affidavit of show cause as well as compliance has been submitted by the alleged contemner in court. Alleged contemner, stop. No. Affidavit of show cause and compliance submitted by the alleged contemner is taken on record. Paragraph copy of the affidavit is made over to learned counsel for the applicant petitioners in court this day. Paragraph on prayer of the applicants, the matter is adjourned. Paragraph, let the matter appear under the same heading on 18th October.
No, my lord, this month can be any day of this month.
18th September, I'm sorry. 18th September.
No problem. Now, my lord, order was, my lord,
Paragraph personal
2022.
appearance of the alleged contemner is dispensed with.
Order was 2022. As soon as your lordship issue notice, then, my lord, the
That
hearing was
happens in
conducted.
all the matters, isn't it? That's the usual practice in all the matters. Please go through the affidavit and come.
Yes, yes.
Next.
No.
Your Lordship. I'm for the petitioner.
Which matter?
Item number 2.
Let it be called.
Your Lordship, praying for Friday, that is 8th. My senior is unwell.
On the earlier occasion also, you prayed for time.
18th September.
Fine. Keep turn.
You are the contemner.
Yes. But the last occasion, the issue is that petitioner wants to donate the 3 plots of land. One
Item number
plot, the
One is occupied by
occupied
Borgata and it's
Borgata,
not
and
private
intervening
plots.
the 3rd plot. I have kindly see this.
Let the petitioner come.
Your Lordship, praying for Friday.
On prayer of the, not Friday, I'll give you a date. On prayer of the applicant petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 19th September.
Grateful, my Lordship.
18th September.
September না?
হ্যাঁ, October। আমি বলেছিলাম ভুল করে, তারপরে আবার কারেক্ট করলাম 18 সেপ্টেম্বর। Next.
September. Item 3.
My application, I am for the. But here they have filed that exception.
They have filed their affidavit of compliance. I have filed an exception to that affidavit of
appearing?
compliance. But Mr.
Mr. Ganguly is.
Ganguly,
appearing.
Ashim
Where is
Ganguly
he?
was appearing.
Is it complied?
My lord, they have passed an order, but my lord, it is delayed and there is no explanation in the affidavit in compliance. If your lordship kindly takes up your lordship's order,
But in absence of the.
no, I don't want to do that. Lordship kindly keeps this on some other day, my lord,
In-
subject to my lord's convenience, my lord.
None appears for the alleged contemner.
I can see my lord, I'm for the contempt, my lord, I'm sorry, my lord, I was in.
Yes,
Number nine.
item 3.
My lord, already compliance report has.
Yes,
been
my
filed.
lord will kindly take up your lordship's order.
Mr.
My
Ashim
lord,
Kumar Ganguly
yes,
is leading
lordship
me, my
knows that,
lord. He
lordship
has gone for medical checkup.
My lord kindly takes up page 30, my lord. My lord, this was my lord, the third, the second.
4th January order.
4th January order, what was the lordship's direction? Lordship kindly takes up the next page at page 31. Since the matter is pending before the Assistant Secretary to the Government of West Bengal, being the respondent number 2 hearing, the second response is directed to consider and dispose of the representation within 2 weeks from the date of communication of this order in the light of observations made by this court in so and so after affording a reasonable opportunity of hearing to the petitions in accordance with law. The decision taken by the authority shall be communicated to the petitioners within a week thereafter. Now, my lord will kindly consider the next page. So, my lord, the hearing was to be given within 2 weeks from the communication. Lordship kindly takes up the next page. My communication was on 6th January itself, which they had received. Lordship kindly sees at page 33. They received on 9th January. So, my lord, 2 weeks from 9th January. So, my lord, 23rd January, my lord, the hearing was to be made, my lord. But what they have done is, my lord, they have waited for long, my lord, and then ultimately, if your lordship kindly takes up my exception,
The representation has been disposed of.
that has been disposed of.
And
But
you
in
are
what,
unhappy with it.
but in what manner, lordship will kindly see?
Can what manner be considered in a contempt application?
No, that cannot be. But they have not. The lordship kindly takes up. This is my affidavit of service. My lord kindly takes up page 6 of my exception. Page 6 of my exception. This has been served upon them. Page 6, I have given the dates. 4th January, your lordship's order was passed. 9th January, this was received by the contemner. Then, my lord, they were supposed to dispose of that representation within 2 weeks from the date of receiving. So, my lord, 2 weeks, my lord, 14 days from 9th January takes us to, my lord, 27th, my lord, January. My lord, they did not do so, my lord, within 27th January. They did not give me any hearing also. So, can you take a page 6? Then, my lord, 27th January, my lord, I had served the contempt notice of the contemner. Then on 21st February, my lord, hearing was given to the petitioner. My lord, after, my lord, more than 1.5 months. My lord, this explanation is not there in the affidavit of compliance. My lord, it has to, my lord, they have given ultimately a hearing and they have this order has been passed. I am not on that. Lordship, in the exception, in the affidavit in compliance, the lordship sees them, my lord, there is not a single line as to why, my lord, this was the reason of the delay. Well, more than 1.5 months, then what was the reason for your lordships to pass this order, directing them to hear out the matter within 2 weeks of communication? Well, there is no explanation. Lordship kindly sees their compliance report, alleged compliance report. Well, no explanation is there. Let him my lord appear personally explain to your lordship why he was waiting for all this.
Paragraph, my lord, on paragraph 9, my lord, the contemner has paid for unconditional apology because of
What was the
my
reason
lord,
of your lordship, my
my
lord,
lord,
to give a
my lord,
specific
that's true,
direction
the
upon
delay
them, my
was
lord?
there, but
Well, let
ultimately,
him appear before your lordship. Lordship kindly issues the rule, my lord. Otherwise,
kindly, that
they are
was
not caring for your
complied with,
lordship's
my lord,
order. Let
kindly
him come before
consider.
your lordship. Explain to your lordship why this delay was there, my lord. More than 1.5 months. My lord, by that time, they were supposed to hear me, pass the reason order, communicate that to me. And sees lordship kindly sees what the
Ultimately, order was
lordship will
passed,
kindly
my
sees the
lord.
gist
Kindly
of the
see the
dates
last
at
annexure,
page
my lord.
6 page 6.
I think that's not necessary. Unconditional apology has been sought, prayed
Yes,
for.
my
Yes, but lordship kindly
Order has been substantially complied.
lordship kindly sees the page 6, just that, my lord, on 27 January, they had given me a hearing.
Dates. I've seen the dates, sir. Reiteration will not help you.
Then, my lord, lordship
You're
kindly,
only delay.
that's the delay, there is no explanation.
I do not think that anything else further is required in this case. You are not happy with the order.
No, that is a separate aspect. That I have challenged before lordship. That matter hearing is being on before lordship. Only thing was the delay should not be there.
paragraph. It appears from the affidavit of compliance that the order under contempt has been substantially complied with. Paragraph, in view of the above, the contempt application being such and such is disposed of. Paragraph, there shall however be no other cause as is declared website.
Grateful to your lordship.
Mr. Ashim Kumar Ganguly is leading me, my lord. He is on
He's
the.
not there at all,
He
sir.
he
I
has
cannot,
already entered, my
I
lord.
cannot
He has
record his
already
name.
entered, my lord.
Give your name.
Item number 4, my lord. I am begging 2 weeks time because the
For the
honorable
petitioner.
division bench, my lord, is going to take up them on next week. That's why, my lord, she
On-
was,
On consent?
No, not to consent.
I have served, my lord.
They have served.
My lord, that 2 weeks time,
On prayer of the alleged contemnor, the matter is
Till
adjourned.
next month,
Paragraph, let the
please.
matter appear. Yes?
monthly list.
Released.
No.
No, 2 weeks.
Let the matter appear under the same heading on 21st September.
Okay.
Item 5.
Item 5, madam. I am for the petition, madam.
I am appearing on behalf of the alleged contempt. I have submitted my affidavit of compliance on the earlier date. Today is the date of filing exception.
My lord, I shall file exception, my lord, but because of the bereavement in the family of the petitioner, my lord, I could not prepare, my lord. So kindly give me 1 week time.
For some time.
My senior is available on the online, my lord.
You're asking for time.
Time, my lord.
You're not audible. Please unmute yourself. Please unmute. You're not audible. You're not audible. Your junior friend is seeking accommodation. So let them-
Kindly allow us 1 week time. Our exception is ready, but it couldn't be happened due to.
Learned counsel for the applicant's petitioners seeks extension of time to use the exception as sought. Paragraph, let the matter appear under the same heading on 22nd September.
My lord, he will be there.
Item 6.
That's, my lord, item 5 also, my lord, he has come and he is in court number 3, my lord, Ashim Ganguly.
Item number 6, eventual, lordship,
Next,
item number 6.
Why appearance be given, my lord?
item numbers, give your
Five.
name. That is what I've said.
No, 5 also, my lord.
Lordship, item number
Item
6,
five.
Mr. Kolol Basu is appearing on behalf of the Howrah Improvement Trust, eventual lordship. I am praying for only not today, eventual lordship.
I'll give you a date in that case. Who is the petitioner?
My lord, in this matter.
I beg to appear before your lordship on behalf of the petitioner.
Through online, my lord.
I do not find who is appearing.
My lord, I beg to appear on behalf of the petitioner before your lordship. My lord, your lordship are pleased to direct the respondent authorities to file their report, and they have on affidavit they have filed that, my lord, and I have also filed my
Transfer
exception.
the earlier occasion to the HIT.
I have also already filed,
Please
my
make
lord,
your
not
submission. Please make your submission.
again and again, my lord,
Lordship,
they are
I am not
taking
in
time,
brief,
my lord.
eventual lordship. Mr. Kolol Basu is
There is,
on
my lord,
behalf-
short point is involved in this matter, my lord, your lordship kindly will not take
then
much
lordship
more
kindly
time.
give me short password, eventual lordship. I am calling him Mr. Basu.
Not today.
Deeply appreciate.
Only not today.
It will appear tomorrow, your lordship.
It will appear tomorrow. Yes.
Day after tomorrow.
Oh,
As you
monthly
love.
list at order করতে হবে না? On prayer of the Howrah Improvement Trust, the matter is adjourned. Let the matter appear under the same heading. কালকে দেবো।
Deeply
Grateful,
appreciate.
deeply obliged to your lordship. Grateful to your lordship.
5th September.
Item 7.
Monthly list is supplementary.
Your lordship, I am for the petitioner.
I appear for the National Highway Authority.
On the last occasion, initially there was a change in brief. Your lordship has directed me to serve the learned GP. I have served, your lordship. The state was supposed to give a report, your lordship.
Mr. Dey, you are appearing?
হ্যাঁ ও তো
Report.
অফিসে সার্ভিস করে এসেছি তুমি আসো আমি জানবো না আচ্ছা I have served you. I served him a copy, your lordship.
Let Mr. Dey come back with
Yes,
the
yes, I was not aware of Mr. Dey was there.
affidavit of service. Learned counsel for the state respondent seeks further extension of time to submit the report in the form of affidavit as sought. Paragraph, let the matter appear under the same heading on 26th September should be sufficient.
Lordship.
26, huh?
Xerox ko দিয়ে দিচ্ছি। Published. মুর্শিদাবাদ।
Item 8.
My lord, I am for the petitioner led by Mr. Supratim Dhar.
My lord, in this matter, we are for the state, my lord. Lord, senior, my lord, Sushant Singh Gupta appear in this matter.
Yes.
Earlier, location, my lord. My lord, I have taken to instruction, my lord. My learned senior Jayanto Samant appearing in this matter, my
Who
lord.
is appearing?
Jayanto Samant, learned senior, my lord.
My lord,
I am from, my lord, in this matter, I am for take instructions, my lord. And your lordship kindly adjourn it, my lord.
You're asking for adjournment.
Yes, my lord. Taking instructions, my lord. I have taken for them. No.
Learned counsel for the state respondents seeks to take instructions in this matter.
Yes, my lord.
Paragraph, let the matter appear under the same heading on 27th September.
Much of
my lord, evidence service be kept on.
Affidavit of service, Raji.
Huh.
Affidavit of service.
my lord.
Item 9.
My lord, I am appearing this matter.
In this matter, Sumon Sengupta appearing for the state respondent, my lord. He is on leg, my lord, on court number. That is, I am paying, my lord, short pass over all, my lord.
No, my lord, one thing may I submit, my lord, very short. There is a judgment. What happened? 1991, you were still vested. Now we filed a suit. State was party. Degree was passed against in your favor. Then they prefer appeal. First appeal paper before the court. Appeal was dismissed. Then what they have done? File another suit. Independent suit. That suit was pending. Now the last order on appeal, but after hearing both the parties, courts says that this is not maintainable at all, this suit. They may take a plea that in 90, the order passed in the degree, passed the degree in 1992. That has been challenged in the second appeal. But till date, no documents has been given, nothing of the neither to that court nor to me. So what I'm paying, my lord, everything will be decided unless and until they say and prove that there is any pending second appeal. That is the reason, my lord, they are not allow us to take any steps in the matter. My lord, may I file a supplementary affidavit of this judgment? Lord, you kindly give me time, my lord.
You are
Sometime.
filing it today?
Yes, but not today because a supplementary affidavit has to be shown. Otherwise, this cannot be, my lord.
On prayer of the petitioner, liberty
Madam,
is granted to
yes,
use
madam,
a supplementary affidavit
My lord,
annexing relevant documents.
the documents mean title suit number 87 of 1999.
Not necessary record, just file it. And please serve a copy to the respondents.
Lordship,
Paragraph on prayer of the respondents, the matter is adjourned.
with copy to the
Paragraph, let the matter appear under the same heading on 26th September.
Lordship. Legal 26. By this time, I will submit. Here also in opposition, they have taken this point.
Item 10, let them come back.
Item number 10, I beg to appear on behalf of the petitioner. Lordship, there was direction for filing the affidavit of service since on the last occasion I could believe me. Lordship, may I place the case? Lordship,
State respondents or there are private
no,
respondents
my
also?
lord, there is,
The only answering this.
yes. Lordship, the petitioner preferred a title suit. The father of the petitioner preferred a title suit against the forest department in the year 1995 because his father came into the possession of this property by a Hebanama in the year 1948 itself. Subsequently, it was found that there has been some acquisition by the forest department challenging that in 1995 he preferred the title suit. In that title suit, the state respondents appeared. However, from the order is at page 21, my lord. It would be found that the order was passed ex parte, and it was found that the schedule is hereby defendant is presently they were restrained from interfering with the possession of the petitioner, my lord. I would take your lordship to internal page 2 of the order. It's page 22.
Yes.
At the second paragraph, my lord, it says written that the defendant state appeared but failed to contest the suit for reason best known to itself. So it was not that the expert, they appeared in the matter, but subsequently they didn't participated entirely into the matter, and the order was passed ex parte. Subsequently, during the lifetime of the petitioner's father, he made a representation before the concerned BLR for changing the records. However, it was not done. He died in the year 2015, my lord. The representation is at page 29, which he made during his lifetime.
Page 20.
29, my lord.
Yes.
Lordship, at page 30, we got a reply from the additional district magistrate and district land and land reforms officer, whereby they stated that there has been an acquisition under West Bengal Estate Acquisition Act. Subsequently, my lord, this petitioner made an effort for getting the records changed in his name. However, that was not considered. In 2018, we came before the Honorable High Court. The matter was heard by His Lordship, the Honorable Justice Harish Tandon, and he directed for an affidavit in opposition. And subsequently, the matter didn't turn up again, and we came back to your Lordship again. On 26 June, the matter came
You're
up.
primarily praying for correction of record of rights.
Yes.
This court doesn't have jurisdiction to do this.
moreover
You're
that-
aware.
Two things, Milord.
Your expression shows that you're aware.
I previously.
Two things, Milord. Kindly comes to page 30. His application has already been rejected under 44(2).
Immaterial, because this court cannot deal with it
Immaterial.
at all.
There is a provision of appeal, and Lordship knows there is a Milord limitation for 60 years that has long expired. Milord, as of today, Milord, he do not
This
have
is
any,
under the specified act. I will not go into merits at all.
Milord, as of today, he do not have any live claim at all. Milord, because there is
Only
no,
one
Milord,
in the-
I'll only, Milord, my prayer is no leave may be given to go before the appropriate forum, because he do not have a live claim as of today.
That also the appropriate forum will decide.
Lordship may
Not this court.
Lordship, Milord, will.
I will only grant him leave,
Not
that's all.
Milord, leave
Lordship,
may not
even
On
if-
merits, the appropriate, the forum will decide.
My only reason before coming before your Lordship was that there was a notification that was served upon us, which is at page 31. It was by the divisional forest officer, my lord. Lordship,
Even prayer is correction.
yes,
of
yes.
record of-
I don't deny that the ultimate prayer was for correction. If I'm on now,
So approach the appropriate authority.
I'm only praying for that leave, that will be enough. Yes.
The petitioner prays for correction of record of rights. Paragraph, the petitioner seeks to withdraw the writ petition and approach the appropriate forum for redressal of his grievance. Paragraph, in view of the above, the writ petition being WPS such and such is dismissed for non-prosecution. Paragraph, liberty is granted to the petitioner to approach the appropriate forum for redressal of his grievance. Paragraph, there shall however be no order as to costs as in certified website.
I'm grateful.
Nothing more in this.
No, nothing.
My learned friend was even trying for that leave. It's
Well, leave, Milord, provided he has a live claim. As of today, he doesn't have it.
Let the appropriate court decide.
Lordship. Grateful.
That will be decided on merits.
He should have, Milord, withdrawn it in 2018 itself, Milord.
Grateful.
Item 11.
Item number 11, my lord, I am appearing for the petitioner led by Mr. Uttio Roy. My lord, similar matters has been fixed on 15th of September. I am praying for adjournment till 15th of September, lords.
An appeal was preferred. That is still pending?
That is still pending, is running in today's list, lordship.
Yes.
Today's fixed for hearing, lords. In view of that, lordship, kindly and similar matter.
15th September in that case, because that has to be disposed of first.
For the division bench, my lord,
That has to be disposed of first. In order for me to take up these matters, the appeal has to be disposed of.
Lordship,
On 15th,
on 15, lords.
let us see if it is disposed of.
Grateful.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 15th September.
15, lords.
Lord, I am for the petitioner, my lord. In this matter, my lord, your lordship, my lord, there is a report filed by the state, my lord. I prayed for my lord to file exceptions to the report, my lord. A copy of the report, my lord, has been submitted, my lord. This is the copy of the
Exception?
exceptions.
Have you served?
Yes, my lord, I have served, my lord. But my
Vandana,
lord, what I am
received a
praying
copy?
for, my lord, kindly hear it, my lord, any other day, my lord. I
Not today.
am not prepared, my lord, today, my lord. Kindly, my lord, any other day, any other day, as your lordship please, my lord. A copy is served to my other side.
Exception filed by the petitioner to the report in the form of affidavit submitted on behalf of the respondents is taken on record.
Copy diyeje kothai?
Paragraph on behalf of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 27th September.
My lord, 27th, my lord, I will be in Delhi, my lord. Yes, my lord. 27th,
28th.
28th, my lord. 28th. Grateful.
Mr. Bandwani, you have a copy of the exception?
Yes, yes. Grateful.
13.
I am for the petitioner, my lord. Against the armed authority construction over the government land, my lord.
In this matter, I am for the respondent number 8.
Private respondent.
Yes, my lord.
State.
My lord, I have.
My lord, sir, in earlier occasion, state was appeared, my lord, Mano Sadhu and Mr. Shushoban, led by Shushoban Bhattacharya.
He is no longer in the panel.
Then Mr. They may be engaged, my lord.
There was a direction for further service.
Yes, yes, I have, that's why my learned friend is appearing.
Yes.
My learned friend is appearing on behalf of the private respondent. I served, my lord, by hand service.
On the earlier occasion, there is an order for further service upon the
My lord,
state.
I have served.
The state.
My lord, the private
State.
respondent. My lord.
Since there is a change of panel, you have to.
My lord, my lord.
Private respondent has been appearing all throughout.
My lord.
Mr. Sengupta was appearing sometime in 2019.
My lord. Initially, brief was allotted. to Mr.
On
Sengupta.
one occasion. After that, no one appeared.
Mr. Manos Sadhu was with.
That was long back. After that, there was a direction for fresh service after change of panel. You have not served.
No. After
So
change
please
of panel.
serve and come back.
My lord.
There was a direction on the earlier occasion also.
Right.
Since the state respondents have not been served, comma, let the matter stand over till 21st September.
Yep.
Please serve in the meantime.
My lord.
I am for the petitioner, my lord, Mrs. Maiti appearing in the virtual mode, my lord.
Yes.
I beg to appear for the petitioner before your lordship.
I appear
Please
for,
appear for the.
but I appear for the state response. My lord, this is the exception, my lord, that against the
Union of
report.
India. You are appearing?
Lord, here your lordship will find the report in the form of affidavit was filed by respondent number 10. And respondent number 8, we wrote.
Respondent number 10 has filed a report.
10 and 8, both. My lord, this is the exception, my lord.
8 and 10, both of them different report was submitted before your lordship.
Yes.
Lord, the grievance of the petition is this, my lord. The concerned authorities are trying to implement one scheme launched by the central government and to be implemented by the government, state of West Bengal. And name of the said scheme is Mahatma Gandhi National Rural Employment Guarantee Scheme. But in the name of implementation of such scheme, what they are doing, they are digging soil of my agricultural land for fixing a hume pipe, which is not at all necessary. Automatically, by natural way, the excess rainwater let out to the canal. adjacent to the plot of the petitioners herein, my lord. There, my lord, the petitioners are the only owner of the entire area where the hume pipe is not at all necessary, and that was the submission before them also, not to put any hume pipe, so that the that will turn into a canal for any other purpose, not for agricultural purpose, and that will change the nature and character. Still, they have, my lord, already went up to, my lord, the plot number 11, and if it is proceeded with further, my lord, then saline water will be filled up with the, my lord, agricultural land, and the petitioners will not be able to cultivate such land for production of, my lord, paddy. So, my lord, my prayer is before the lordship, my lord, not to, the respondents are should be restrained from implement the such scheme, my lord, which is not necessary there, my lord. My exception to the, my lord, affidavit, my lord, your lordship kindly have a look. My lord, your lordship kindly have a look to the exception on affidavit on behalf of the writ petitioner against the report in the form of filed by the respondent number 8.
Yes.
Your lordship will find that in the said purported report, it was not disclosed by the, what for such hume pipe will be fixed within the area belong to the petitioners herein. And paragraph 3 of my, my lord, exception, I have stated that paragraph 3, page 2, purposely and motivatedly did not disclose the real state of affairs, and accordingly it could not be ascertained that for implementation of the scheme, namely Mahatma Gandhi National and Rural Employment Scheme, there is any necessity to excavate soil for fixing hume pipe. It is apprehended that the entire property of the petitioner will be turned into a canal by losing its character of agricultural land, which is the main source of income to maintain their livelihood. Next, your lordship will find.
What is your right over the said land?
I am the owner. I am the rayat over the property. I am the owner of the land. What, my lord, the actual fact behind it, my lord, the local
The land
political
was
leaders,
leased out to you.
my
The
lord.
land was leased out to you. You are a lessee in respect of the land.
No. I am the entire area is, my lord, rayat land, excepting plot number 11, which belongs to, my lord, which was leased out, but now I am not, my lease has not been renewed. But I am not, I am not on that, my lord. If, my lord, any hume pipe is, my lord, fixed by the concerned authorities in that event, my lord, my entire area, the petitioners, which 26 petitioners are before the lordship, and without no other rayat is there, my lord, except in the petitioners before the lordship. Whether it is at all necessary or not, we are the best person to know, my lord, not the concerned authorities. What, my lord, behind the back, this is the plan of the concerned authorities, that if, my lord, the hume pipe is fixed there, no outlet would be there, and it will turn into a canal, and local political leaders who asked me to take it on lease for rearing, my lord, farm, prawn farming, but they will be able to get the property of their own on lease from us. We will be compelled to, my lord, hand over the property them. This is the, my lord, reason for which, my lord, they are trying to fix the hume pipe on our land. This is not the land of the government. This is our own land, my lord, land we are cultivating, and this is the only source of livelihood of the petitioners superior lordship. They are the poor villagers. Now, whimsically, they are trying to, my lord, fix the hume pipe, which is not at all necessary there, my lord. They can implement it anywhere, my lord, not within the land of the petitioners, which is not necessary there. And if your lordship so pleases, my lord, your lordship may appoint any, my lord, survey pass advocate, my lord, and he can go there and to verify the same, what is the submission with your lordship. RI or, my lord, any inspecting officer cannot say that it is not, it will not cause any harm to the petitioners. Cannot be said, my lord, having no knowledge regarding that, my lord, area.
Yes,
All the popular plots of land are belong to the petitioners.
Yes.
First and foremost,
Microphone, she'll not be able to hear you otherwise.
Well, firstly, my lord, my learned senior friend, my lord, was not able to satisfy your lordship with regard to the petitioner's locus over the land in question, my lord. The petitioner does not have the locus to maintain this writ petition. This particular area, which is DAG number 11.
11, the petitioner admits it is not her land.
It's not her land.
But it is adjoining her land.
No, my lord, it's like, I'll show you lordship. And if your lordship kindly takes a page
2 of the.
page 33 of the writ petition. There's a Moza map.
Yes,
Lordship got that Moza map, my lord?
yes.
My lord, if your lordship kindly sees, it is very illegible. There is this, my lord, a staircase type of, my lord, this,
Yes.
my lord. Atop that, my lord, your lordship will see DAG number 11, Agaro.
Ten, I can see 13, where is 11?
It's very, my lord, illegible. If your lordship sees here,
That is 13.
11, my lord, if your lordship strip of land, strip, very long strip of land, if your lordship sees on the,
Yes.
where it is, in the scale, it is western side. In the scale, it is western side. Because the lordship has to,
I can see 13. I cannot find 11. 10, 13, 12.
13, that side, my lord, that side is 13. On that
This side is 13. Right side is 13.
13 and 14 are there.
Yes.
And the left side, if your lordship kindly sees, DAG number 11.
Yes. Yes.
Your lordship seen that?
Yes.
And in between this, my lord, side portion, DAG number 12 is there. There.
Yes. Yes.
My lord. Now, my lord, this DAG number 11, this small strip of land, this entire strip of land belongs to the Irrigation Waterways Department.
And the petitioner is claiming 7.
Petitioner is claiming, my lord, ownership over the next land. 87, 88, 89. Those blocks of land, your lordship sees on the further on the left hand side. After 11, my lord, 87, 88, 89.
Yes.
Have you also seen that? Now, my lord, the room pipe is being constructed over DAG number 11. It is not touching, my lord, we have categorically stated in our report, it is not touching the western side boundary of the petitioner's land. It is not touching the entire DAG number 11 even. We have specifically stated in our affidavit. The petitioner, my lord, by print of this writ petition is trying to forcibly hold possession of the land wherein the lease has expired long time back in 2011, 2012.
That is 11.
11.
But the petitioner doesn't claim any right over 11.
The petitioner says, my lord, that was the contention. The petitioner says that I am the lessee of the DAG number. My lord, that is what the petitioner's contention. Petitioner does not want a developmental work to be done in DAG number 11.
But you can do that without disturbing the petitioner's land.
We cannot, my lord. We have stated in on a oath in our affidavit. We are not doing so. If your lordship looks at our affidavit, my lord, there are 2 affidavits. Your lordship kindly sees the affidavit report in the form of an affidavit on behalf of the respondent number 10. Paragraph 5.
Yes.
Well, it is humbly submitted that the inquiry report pertaining to the field inspection conducted by the inspection officer on so and so of the land classified as Noinjuli states that after physical verification, it was found that the Gram Panchayat will fix the path with hewn pipe and they can easily access the land for cultivation with machinery. The report further adds that the crop production will not be hampered if the Mahatma Gandhi National Rural Employment Guarantee Scheme is executed. Any kind of digging has not been done in the private boundary of the land where cultivation was being done. And after careful measurement in presence of the local villagers, it was revealed that the water passage being dug under the scheme do not cross the western boundary of plot number 11. After the western boundary, the petitioner's plots come. A copy of the inquiry report is annexed here too. The inquiry report is here at page 5. In fact, the petitioner came up before your lordship, my lord, because we had taken a resolution not to continue with the lease. If your lordship kindly looks at the report in the form of affidavit on behalf of the respondent number 8.
Let there be a joint
My lord,
inquiry.
your lordship kindly, my lord, sees page number 3. My lord, this is the entire intention. Page number 3 of the writ petition. Page number 7, paragraph 3 of the writ petition. Your lordship got that.
Yes.
Adjacent to the lands of the petitioner, so and so, Dagnoma so and so is situated to the eastern side of 2 plots. This land was previously recorded as Noinjuli, but the irrigation waterways department leased out part of the plot number so and so, measuring so and so, and the petitioner number 5 and 6, along with others, wherein Shodananda Dev was leased out, and the petitioner number 5 and 6 were leased out land measuring so and so, renewable each year, after the year 2012. It was never renewed. The government had stopped renewing the lease, but the petitioners are still in possession of it and have been cultivating the same till date. Well, that is an admitted position. They are wrongfully holding that number 11. Plot number 3. Plot number 3. My lord, this is on this
Plot
side.
number 3 is the square.
My lord, I'll tell you, lordship. If your lordship looks at the map, then again this is a small strip.
Yes,
My lord,
yes,
on the top, this side,
yes.
and 3 is there.
I've seen that. 3 are.
3 is there. Well, all in all, that developmental work is supposed to be carried out. The petitioners admittedly are in wrongful possession of that dark. We have already taken the decision not to renew the lease since 2012. It is there in my affidavit of respondent number 10. Now, my lord, the petitioners does not want this hume pipe to be constructed because the petitioner is wrongfully holding that land and admittedly is cultivating it. একটা স্টেপলার আছে দিদি, একটু স্টেপলার আছে দিদি। মানে মামলা ধরেছে, পিন শেষ হয়ে গেছে দাদা, পিন নেই।
Yes, it is your admission, madam, that you're holding on to the plot number 11.
11, that was, my lord, that is protected, that is there, my lord, for protection of the royalty land of the petitioners, and that if that plot number 11 be excavated, my lord, in that event, then saline water will enter into. Not that I am not, my lord, if I say so, that I am in possession of the, that is not the correct proposition would be, because of the fact that if they are trying to excavate 11, in that event, the canal, saline water canal is lying adjacent to the plot number 11. If it is excavated, then saline water will enter into. This is why subdivision, only subdivision, my lord. If any sort of excavation is made, my lord, then the saline water will enter into the royalty land and it will convert it to a canal. And in that event, no cultivation could be done by the petitioners before your lordship. This is the only sufficient before your lordship. If your lordship so pleases, my lord, your lordship may appoint anybody at the cost of the petitioner. Whether the drain water would be automatically drain out, or without any sort of further drainage system is required. This portion may be not determined by your lordship. By any way, whatever your lordship pleases. What is their harm, my lord, if I do not want to allow them to fix any hume pipe on my right, then what is their harm?
Madam, you cannot stop a public work on a land which doesn't belong
If
to
it is
you.
not at all, required, then
That is
how
not
the public work,
right.
who will be benefited,
That
none
is
of
not for the petitioner to decide. The government will decide whether it is required or not. It is beyond your jurisdiction to
entire
decide.
property belong to this family, not nobody else is there. The property in
Your
question,
land
which I
is not-
mentioned.
I'm sorry, the writ petition is not maintainable at all. Your land is not disturbed. The government is making a project, a public.
My land is being used, my Ravatina, over my Ravatina, they are trying to do so.
Plot number 11 is being utilized. That is not your
Plot
land.
number 11 is not only plot. Other plots are there. I have mentioned it before, your lordship. Your lordship just now seen that.
Please come to your writ petition. Paragraph 3. Paragraph
Yes.
3 of your writ petition.
Yes.
You say that plot number 11 is being utilized.
Plot number 11 is the plot. I told you, lordship, that plot number 11, I am the owner of plot number 11. I was granted lease that is not renewed since
You are not the owner of the plot number 11, madam. I'm sorry. The petitioners are not the owners of plot number 11.
That's true, my lord. I never said that I am the owner. I never said, my lord. But that is protecting, that plot is protecting my right land. That plot number 11 and 3. 3 is my right land. Those two plots are protecting my land so that saline water could not be entered into in the cultivable land, agricultural land.
I'm sorry, there's no case. There is no case. It has to be dismissed.
My lord, your lordship, kindly one line may I, my lord, place before your lordship. My lord, executive officer, my lord, what has stated. My lord, page 3 of the report submitted by respondent number 8, your lordship will find. Page 3, it is submitted that the lands acquired in favor of the Department of Irrigation and Waterways are in the custody of the executive engineer who are entitled to execute various scheme projects for larger public interest. Are the competent authority to deal with eviction, removal, encroachment. My lord, I am not encroaching that. That is there. I am not. I am in possession means that is protected. That is protecting my right land. That is my submission. Not that I have said that I am the owner. I never said that. Irrigation and Water Department may be the owner of the land, but that does not mean that they will launch a project which will hamper the right of the petitioner.
It is not hampering your right at all, madam. That is not
What I am,
from the sketch map.
Excavation work is done, then my property will be turned into a panel.
Please come to page 33, the sketch map. It is your document.
My lord, another thing, my lord, plot number 3 is the Rayati land. My lord, it will be blocked. My lord, it is specifically stated page 4 in my exception respondent number 10, my lord. Kindly see paragraph 4.3 and 4.6, my lord. Kindly read out, my lord. Kindly allow me.
What do you mean by blocked, sir? This is government land. You cannot leave the government land for your ingress.
My lord, kindly allow me to page 3.
Of your exception?
Exception, my lord. Respondent number 10, page 3, 4.3, my lord. Adjacent to the land of the petitioner, being such and such, the respectively belong to the petitioner. 11, plot number 11 is situated eastern side of this plot. This plot is previously non-duly and irrigated. Leach out and about 86 decimal out of Atho of the petitioner, including enter who leased out Atho decimal and renewable each year. But after Atho year, government renew the lease, all are also not taken into rent purpose. But petitioner is still in possession. And kindly come to page, next page, page 6.
This is your primary issue. Petitioner is still in possession, so government cannot do anything on 11.
My lord, page 4 and paragraph 6.
Yes.
My lord.
Yes.
Plot number 11 on eastern side of the petitioner is now being excavated up to level, my lord, specifically stated up to level of such and such plot, so that western water of canal is entered into the plot number 11, which itself is converted to a canal, but the day entry point is blocked by plot number 3.
Now keep this open and come to page 33 of the petition. Where is the canal? Where is the plot? Please come to page 33.
My lord, kindly see the
Polaberia Khal is to the west of your plot. And 11 is to the east of your plot. So if east is excavated, how will the west canal come into your plot?
canal, my lord, totally east to west, my lord. Adjacent plot, my lord. This is the
Please
3.
show me the canal in the, this is your sketch map.
Yes, my lord.
Please
This
show
is
me
the
the
3.
Yes, 3 is on top.
Yes, my lord. This will be blocked.
What
It-
will be blocked?
3, my lord.
That is 3, yes.
3. This is not the plot of the government, my lord.
87, then 11.
No. My lord, the strip of land, my lord. This is the 3. 11 and going to touches the 3, my lord. In the top, my lord, this is the
Yes, so after 3, there is also space. 11
No.
will not block 3.
after 11. This is the 3, my lord. 3 is the right land.
11 ends, then top is 3.
Yes.
Yes.
That means the entire canal will be blocked because this is the 3 is the right land. That is when I have
And
specifically
where
stated.
is the canal? Canal is on left, this side, left. It has no connection with 11.
Yes, 11. They accept.
Canal has no connection with 11. 11 is on the right, canal is on the left of your land. It's not on the same side. Yes.
My lord, my learned friend stated that some portion of the 11 also excavated for the purpose of canal, my lord. That's why, my lord, it has been specifically stated here, my lord.
If it is within the boundary of 11, you have nothing to say.
My lord, entry point is blocked by 3.
No, entry point is not blocked by the canal. There's a dam also, there's a bath also beside that. An embankment
This
is
is the
there.
picture. If your lord see that, there is a block. This is the entry point, my lord. Kindly see. That's why Mrs. Mighty, your lordship, said kindly appoint any person to go there.
If I will not fail to satisfy your lordship.
Let there be a joint inquiry.
Yes.
A joint field inquiry. Heard learned counsels for the parties.
I take a lordship's leave.
Oh, তার আগে কোনো exception.
May I take a lordship's leave, my lord?
Exception used by the, who will, Mr. Siddiqui? Who will be appointed?
My lord, I think, my lord, the BLRO concerned along with the Amin. Because though it belongs to the, and some officials of the irrigation waterways department also, because the Amin can measure the plots and where it is being, the work is being carried
In
out.
presence of the petitioner and the
In pres-
petitioner will also be at liberty to appoint his own Amin.
Yes. Yes.
May I need submit one minute, may I suggest you
Government
submit
survey-
your lordship?
My lord, government survey and
Any
Amin.
survey past,
I'm good.
survey past lawyer, your lordship kindly, if it is appointed, my lord, whoever may be the advocate, my lord. Otherwise, my lord, Amin already went there, but behind our back and submitted a report that there is no problem if him by
Advocates, my lord, subject to correction by my lord, advocates will not be able to, my lord, find
No,
out
no,
which
High
is the
Court-
portion of that land.
There is a panel of the survey past lawyer in the High Court, my lord, even.
Survey past lawyer.
At the cost of my learned friends.
Yes.
I'm grateful, my lord. I'm taking your lordship's leave, my lord, my learned junior.
There should be
There is a panel in the High Court, my lord. There is a panel of the High Court. In the High Court, even panel, there is a panel of
Only
survey
my
past
lord,
lawyer.
learned court below is available. Local area, my lord.
There is no survey past panel, advocates panel.
But in the High Court also, my lord, survey past lawyers panel is there.
There is no panel in the High Court, I believe.
As I knew, my lord, about 10 years back, my lord, there is a panel
Years
of
back,
survey
it's not
past
like
lawyer.
that.
Today I do not know, I cannot say, my lord. Today I cannot
And
say.
then council say that there is no panel. So let the government surveyor do it in presence of the petitioners. The petitioners will also be at liberty to appoint their own surveyor, who will jointly do it.
As in lordship, my lord, as in lordship. Otherwise, RI will
By
not
the
do anything, my lord.
petitioners to the reports in the form of affidavit submitted on behalf of respondent numbers 8 and 10 are taken on record. Exceptions. Paragraph, heard learned counsels for the parties. Paragraph. it is submitted on behalf of the petitioners that the plot in dispute, being plot number 11, was leased out, plot number 11, which is adjacent to the Rayati land of the petitioners, was leased out to the petitioners by the government, and the said lease has not been renewed after 2012. Stop. The petitioners claim to be in possession of the land till date. Stop. The grievance of the petitioners is that the government is trying to excavate plot number 11. What is the project? For implementation of Mahatma Gandhi National Rural Employment Guarantee Scheme, which shall lead to water from the canal falling into the said land, resulting in inundating the petitioner's land, comma, thereby making it unfit for agriculture. Stop. The respondents deny and dispute the contention of the petitioners and submits that under the scheme, comma, the Gram Panchayat shall fix the path with Hume pipe, HUME, Hume pipe, which shall give easy access to the land of the petitioners. And the water passage being dug under the scheme does not cross the western boundary of plot number 11, which is adjacent to the petitioner's lands. Paragraph. Upon consideration of the submission made on behalf of the parties, comma, this court is of the view that a joint field enquiry is required to be held in order to ascertain the scenario. Paragraph. In view of the above, comma, in view of the above, comma, a joint field enquiry be held by a survey past engineer appointed by the respondents in presence of it should be appointed by the BLLR.
Yes, my lord.
Appointed by the Block Land and Land Reforms Officer. in presence of the other respondents, as well as the petitioners / their authorized representatives, to ascertain the position of the land of the petitioners vis-a-vis. Yes.
Your lordship, Milord,
Is Amin.
joint
So
inspection.
surveyor will be appointed.
Yes.
Appoint a surveyor, surveyor engineer na. In view of the above, কি বললাম বলুন ওখান থেকে? A surveyor be appointed by a surveyor. Appointed by the Block Land and Land Reforms Officer / their authorized representatives in order to ascertain the position of the land of the petitioners vis-a-vis the excavation work being undertaken by the authority. Stop. The petitioners shall be at liberty to appoint their own surveyor along
Yet
with
to
that
tell
of
us,
the government to hold a joint field inquiry.
My lord.
Such report be such na kore the joint field inquiry report be submitted before this court on the adjourned date. Paragraph, let the matter appear under the same heading on how long should you take? 1 month?
1 month.
5th October.
5th October, as you know. Grateful, deeply obliged to you, lords.
My lord, in item number 15, I'm
Not called as yet, madam. Some patients.
Milord, item number
Please switch on the microphone, it's switched off. Switch it on.
our senior counsel Shoma Mujumdar sir is out of station, and another counsel, Supratim Lal sir is suffering from viral fever. So I'm praying for not this week.
Your lordship kindly remembers that matter. On the last occasion also, time was taken on the ground of learned counsel who was, it was submitted, he was in Delhi, he was standing outside.
This is that alleged
That,
unauthorized.
that alleged, that.
Yes, my lord,
unauthorized
yes, my lord.
transfer.
Direction was given to the
My lord,
Howrah Jilla
please
Police
make it
Officer.
not this week.
It's been dragged, my lord, for considerable long time. It's being dragged, my lord. On the.
Please be ready on the next occasion. Because sufficient time has been granted to all the parties.
Yes, my lord. Sufficient time, my lord. Every time they're coming and taking the time.
On prayer of the petitioner in WPA 1688 of 2019. The second matter, you're the petitioner.
Yes, my lord. Yes.
Comma, the matter is adjourned. Paragraph, let the matter appear. Please be ready on the next occasion. Let the matter appear under the same heading on
16 also, my lord. 16 also.
27th September.
27th September.
Grateful.
Much.
15 and 16 are running analog.
Yes, yes, yes. Analogous. Well, without any granting time, without granting any time for
Ready
that.
on the next.
Much.
Next, 17. 16 action. 15, 16 together. 17.
17, my lord. But I'm paying only not today, my lord. I have to take some instruction from my client because this is an old matter.
You're the petitioner.
I'm a petitioner. Any day, ma'am.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 14 September.
Yes, yes. I'm grateful.
Not I'm for the petitioner. No, my lord, your lordship kindly,
We have the state led by Mr. Answer moderator.
but kindly look into your lordship's order dated 12th June of 2023.
Yes, you were supposed to take instructions.
Yeah.
You're ready
have
to
to
take
take instructions.
instructions? Yes, what is your instruction? Why was the prayer rejected?
Lord, I have taken instruction newly briefed, my lord. And my lord, this is the fact, my lord, without affidavit, it cannot be decided. It's a long matter. And my lord,
But I have
give me
specific,
time, sir. I will take instruction, my lord.
but I specifically challenge a clause of a notification, but that is page 107.
Let him come back on affidavit. Since the notification has been challenged.
Yes, yes.
Learned counsel for the state respondents seeks to use an affidavit in opposition to controvert the factual aspects in dispute. Paragraph, affidavit in opposition be filed within 2 weeks, opposition?
3 weeks.
Yes. Within 3 weeks from date, stop affidavit in reply, comma, if any comma be filed within a week thereafter. 1 week should be sufficient.
Yes.
Paragraph, let the matter go out of list for the time being, liberty to mention.
Let the matter appear in the monthly list of November.
Mention, I think.
Nineteen.
My lord, in this matter, my lord, I am appealing for the petitioner. Last occasion a report. এটা কবে কাটটা দাদা?
You received a copy?
3rd August কি?
Yes.
The land of the petitioner is there, my lord, for the purpose of construction of a ring, but the land of the petitioner is utilized. Though formal proposal was made by the executive engineer for acquisition of the same, ultimately no acquisition has been done. But matter has been utilized, pursuant to which a report was sought for. If your lordship can consider the report itself. This is my sum and substance of my land has been utilized without any acquisition. Though there is a formal, initially a formal proposal was there. If your lordship can consider the report itself. Page 3. কি বলছে তুই যা দেখে নে তুই যা।
It is more or less admitted. Mr. Bandyopadhyay, what do you intend to do now? Because you have utilized the land.
Well, it is true, my lord, as it appears from the report, my lord.
So either direct purchase or 2013 Act. These are the two
But
options.
there is no demarcation as on the subject to question, my lord, from the status report, my lord will not.
Let the executive engineer make a demarcation. And to take a step, appropriate step to the my lord matter for payment of the my lord the.
There cannot be payment of compensation unless it is acquired.
There is no occasion on the point.
It has to be acquired under the 2013 Act, no other. The two alternatives are direct purchase or 2013.
2013 Act. So as on this day, my lord, the state is not coming forward with a specific report. What is the quantum of land they have utilized? I have made representation that the land has been utilized. It is for them to ascertain or by joint inspection that yes, this portion has been utilized. Now, one authority is saying that it is the duty of the other authority. But kindly considering that as well.
Let him make an application, the
That will not
for the
help, Mr.
executive
Bandyopadhyay.
engineer and he will take decision.
What wrong the land losers has
After
committed,
joint
my lord?
inspection- After joint inspection and take. for payment.
Because your interdepartmental letter says that you have proposed a
Yes.
fresh acquisition.
Yes.
So let that happen.
Yes.
Let there be a fresh acquisition within a
Yes.
stipulated time frame.
Yes.
3 months for the proceeding to conclude.
Another new act.
After my joint inspection and demarcation of.
It is.
Part of the proceeding.
It
If you have to acquire, you have to. do
demarcate
demarcation.
survey and enter into position. This is there already in the
That's
statute.
mandatory. The law says, and it is part of the proceeding.
Yes, yes, my lord.
Report in the form of affidavit submitted on behalf of the fourth respondent is taken on record. Paragraph. It is not in dispute that the land of the petitioners was utilized by the state respondents for the purpose of construction of ring band. Without acquiring the same. Stop. Obviously, no compensation was paid to the petitioners. Stop. The report in the form of affidavit submitted on behalf of the respondents indicates that since that though proposals for acquisition of the land were made by the authority earlier, no acquisition proceeding could be initiated. Stop. It also appears from a letter issued by the Additional Land Acquisition Officer, South 24 Parganas, to the Executive Engineer, Kakdeep Irrigation Division, South 24 Parganas, on 4th September 2013, that a joint verification was required before finalization of acquisition and compensation. Learned counsel for the respondents is not able to apprise the court as to whether such joint verification was held. Paragraph. In view of the above, this court is inclined to hold that since admittedly the land of the petitioners has been utilized by the respondents, and the respondents proposed to acquire the said land in accordance with law, who should be the relevant respondent to initiate?
The initiate reference should be made by the executive engineer. My lord will find the last page of the report. In terms of the letter, executive engineer forwarded the resubmission of fresh land acquisition proposal.
Page 7.
Yes, my lord, page 7 from the executive engineer to the LA collector. My lord, got it.
Yes, yes.
This is a fresh proposal which has been forwarded by the executive engineer. That too in the year 1914. So
all this is over.
So my lord, the direction we passed upon the executive engineer to fresh proposal to the land acquisition collector, and land acquisition collector initiate proceedings with the specific trade. And one thing, my lord, my lord was earlier matters directed the principal secretary to
exhibit that, what was,
Because of direct purchase.
that helps us, this land is a great, ultimately get.
This is acquisition. That
No,
was
no,
of
that
direct
is, I'm not on that. That's why, my lord, some responsibility to both the authorities. Otherwise, my lord, they'll not come together.
purchase. Last night in view of the above, this court is inclined to hold that. The executive engineer, comma, Kakdeep Irrigation Department, Division, comma, being the
Respondent number 7.
7, being the 7th respondent hearing, is directed to initiate proposal for acquisition of the land under the Right to Fair Compensation Act 2013 to the land acquisition collector, comma, South 24 Parganas, comma, being the respondent number
2.
2. Proposal within 2 weeks. Proposal will be sent within 2 weeks. 1 month, 1 month. Within 1 month from the date of communication of this order, stop. Upon receipt of such proposal, comma, the second respondent
Third
shall.
respondent, my lord, because the second respondent was termed as the Act 1, collected under the Act 1, and third respondent is collected under Act 30 of 2013. That's the new act.
The proposal will be given to the.
So third respondent, the collector is the same person, but two acts are mentioned differently. That's
The third respondent.
yeah, third
Second
respondent.
now for a proposal to the third respondent.
Third respondent, my lord.
Submitted before the third respondent. Paragraph on receipt of such proposal, comma, the third respondent shall initiate proceedings under section 2013 of the, under the Act of 2013 and take the proceedings to its logical conclusion, including payment of compensation
Act 1
to the petitioners, comma, within 3 months thereafter, 1 month and 3 months.
Well, instead of respondent number 3, my lord, it will be respondent number 4 will be better, my lord.
4.
Otherwise, it will be very difficult to, my lord, the
So,
implement the order.
special,
What is the special land acquisition officer?
but the character, apart from character, will use the
Respondent
What
number
is the
4,
special land acquisition officer?
well, let him do this, my lord, work, my lord. Will be otherwise, my lord, it will be very difficult, my lord.
Who will initiate the proceedings under the?
notification will issue, the collector has the only power.
Your report says the collector was,
My lord, your lordship directed respondent number 4 to take step to the lord and he will
please come
take
to your
step, my lord.
report, it says collector,
The collector will issue
Special
the
land acquisition
notification.
collector, my lord, so
land acquisition collector. Proposal was given to him for initiation. So it
Can
should
I-
be the collector.
Special education officer has no
According
authority
to
to issue the
your-
notification.
to, my lord, implement the my lord's order, my lord. I know
It
that,
is-
my lord. Then contempt will, my lord, arise.
Yes, he'll come.
Yes.
If it cannot
My lord,
implemented, he'll come.
no, my lord, therefore, my lord, I am saying, my lord, before the lordship, my lord, special land acquisition, I shall talk with him, my lord. He will take step, my lord.
He'll take, but the special, no. Notification,
Your report says the collector.
notification cannot be issued by the
collector.
under the special land acquisition collector.
My lord. But in spite of that, I am, my lord, praying.
But the special, subject to question of my learned senior friend, the special has no authority to issue the notification.
করবে না, ও তো এলাকা collector কে deal করা আছে।
হ্যাঁ সে যাই, কিন্তু এলে কালেক্টর তো
Otherwise, collector নিজে থেকে বলে দিচ্ছি হবে না, তুমি নিজেও জানো আমিও জানি। আবার মাইনারের কাছে আসতে হবে, আবার কন্টেম্প হবে, অনেক
একটা নিয়ে সেটা না ওকে জড়িয়ে রাখবে, কিন্তু স্পেশাল কাল কিছু বলে বিয়ন্ড মাই জুরিসডিকশন, বিয়ন্ড মাই জুরিসডিকশন।
Yes, it will be the special land acquisition officer.
Because the subject
If the state says so, let it be, the order has to be complied with.
that is only.
So the fourth respondent, let us see.
It will be
Third
better to comply your lordship's order.
third গুলো সব fourth করুন। Oh, no, ওটা করুন, the special land acquisition officer.
Can you record that in terms of the submission into the state? Otherwise, well, in subsequently they came forward and said, I have no authority to initiate any proceedings, well, I'll be in this way.
ওটা কি বললেন তো নিবে অব্দি আবার কৃষ্ণার স্কিম, হ্যাঁ ওটা দেখে নেব।
ওই জন্যই তো আমার
এখানে একটু ঢোকান, কমা দিন, as suggested by learned counsel
Yes.
for the respondents.
grateful to your lordship. তাহলে সবাই বেঁচে থাকবে।
1 month and 3 months.
Grateful to your lordship.
হ্যাঁ হ্যাঁ হ্যাঁ। With the above instructions, disposed of.
Within 3 months.
আর
Report be kept with the record, my lord. Grateful to your lordship, my lord.
Appear on behalf of the petitioners. But in this matter,
In this matter, I am appearing private respondent, total 12 private respondents.
You're appearing for all of them?
Yes,
Mr. Dev for the state?
Yes, madam.
Previous occasion, my lord, I filed the report.
Twenty.
I know. এই ও কার্ড
Private
Yes.
this is on the last occasion, this status report had been filed. Your lordship kindly, if your lordship kindly goes through the report,
Had not been served. The previously no notice was served of it.
well, he is appearing for the first time.
In the year 2019. And second time, when it was mentioned, this matter,
It had, everything has been served, a petition has been served.
but after a long time, the matter is appearing in the list, but without service any notice.
যাতে এখন তো অ্যাপিয়ার করেছো
Yes, sir.
এখানে প্রাইভেট রেসপন্স
All the private respondents had been served. I have submitted the affidavit of service also.
So once you are served, why will it be served again? You are not put on notice?
Last time, without any notice, madam.
What last time?
You are not ready today. What is your submission? You are not ready today? Yes?
Only, they supplied only out of 12, 6 registered deed has been supplied. The private respondents constructed their shop room on the basis of their land after purchasing the landlord who donated the land, some land in favor of the school.
So you should come up with your documents.
I want to file short affidavit, my lord.
No, affidavit is not required. Let us, yes.
The land had been acquired. The land had been acquired by the state authority for the physical position of the handing over position of the land in favor of the school. It had also started way back 1960. Now, my learned friend is coming up with a proposal that it had been purchased.
Yes.
How an acquired land could be purchased?
the form of evidence দাও না না হলে আর কি করব
In that case, Mr. The affidavits will be
Yes,
required.
my lord.
Because he claims to have purchased the land. The private respondent cannot come up with a report. Let him come back.
Yes,
Let
ma'am.
affidavits be exchanged.
So, Lord, it stands as a matter of record. Lordship, kindly, I can take your lordship to the relevant annexures,
The private.
wherefrom it would be evident that entire land had been acquired by the state authority. And
Yes. But if since the private respondents claim to have acquired title over the plot, let them come back on affidavits. Let the matter be decided on affidavits. Can't help in such matters. Upon consideration of the submission made on behalf of the parties, this court is inclined to hold that the matter needs to be heard on affidavits. Paragraph, affidavit in opposition be filed within 2 weeks.
2 weeks, ma'am.
Mr. Dev, will you also come back with an opposition?
My lord, we have already
Since
filed the,
I'm directing affidavits,
my lord, we have already filed the, if necessary, my lord, I can.
within 2 weeks from date, stop affidavit in reply, comma, if any, comma, be filed within a week thereafter. 1 week. Paragraph, let the matter go out of list for the time being, liberty to mention. Mention upon completion of affidavits, I'll take up the matter.
Your matter be fixed on any date.
Liberty to mention.
Liberty to mention.
Mention after completion of affidavits, I'll take up.
Well, in the event they fail to file the affidavit, then also this.
That's given a direction. They want to file an affidavit.
Well, may I file the?
There are various factual aspects to be determined.
Well, may I file the observations, statements of observations in respect of the status?
Reply,
But the copy has not
include
been,
your documents in that.
All right, all right.
the copy of report has not been served upon me.
We'll come back on affidavits. Yes, next. 21.
দরকার নেই ছাড়ো না এসে এখন কি হবে এটা
Your Lordship, I am for the petitioner, my lord. In this
State.
case, my lord, the
What is
lands
your
of the
report?
petitioner has been.
My lord, the last occasion, my lord, had directed for a report, my lord. There is a slight difficulty, my lord, for which I will be seeking a specific order, my lord. My lord, the BLRO has to demarcate the land, my lord. And my lord, if there is a direction from the court specifically on the BLRO to read petition to the and my lord, in the presence of the PHE officials and the officials of the NHA, I believe, my lord, we will be in a position to understand, my lord, that whether how much compensation and my lord, and how fast we can process, my lord.
Have you seen the order passed on March 16?
My lord,
The authority subsequently decided to hand over shift the pipeline
my lord,
and take over the land to the petitioner.
my lord, that
The
was the,
report was called for only to disclose how and when the land will be restored and
Well, now-
compensation paid.
my lord, now the difficulty we are facing is we are not in a position to demarcate the exact land of the petitioner. So how much we need to shift and whether we need to shift at all, or whether we can go ahead and acquire and compensate, my lord, the demarcation of the BLRO, my lord, in the presence of all parties is extremely important, my lord. And if my lord will direct, my lord, I believe the BLRO is also a party as respondent number 8. My lord, if the respondent number 8 is directed to
Direction
My lord.
is your man.
My lord.
He can do the needful.
My lord, primarily, my lord, the directions were as it was upon the PHE, my lord. I am just besieging, my lord, without going into any counterfight allegations, counter allegations within the departments, my lord. If there is a specific direction on the respondent number 8,
A report has already been filed.
my lord, I am trying to help my
Yes, sir, I am seeking
learned
help.
senior
I am
friend, my
seeking
lord.
help.
I am not,
I am waiting for his
my
report,
lord.
so that they have stated.
My lord, so far as my lord, I am concerned, my lord, I have advised my officers, if the land has been taken not in a proper manner, it has to be made good to the petitioner, whatever may come, my lord. So, my lord, that is the only humble request, my lord. Let the respondent number 8 be directed to be a demarcation of land may be carried out, my lord, in the presence of the petitioner, respondent number 7, and the respondent number 9, my lord. I believe, my lord, this will give the clear picture even for my lord.
Authority,
My lord, I think,
the requiring body. How are they involved?
my lord, it is perhaps the area which covers the national highway.
My lord, one be on a national highway. So naturally, for widening the national highway, the state authorities, my lord,
My lord,
directly.
the national highway will be the requiring body when it comes.
At
my lord.
national, then what they did, my lord, upon the lands of the petitioners, they have shifted the pipelines and what caused damages to plots measuring near about 7 decimals. I am seeking
My lord,
help from
my
the
lord,
state.
perhaps, my
They are
lord,
helping us.
it will be nobody's case, my lord. At that particular area, my lord, in the Tomluk area, water supply of drinking water is of immensely important, my lord, because of the arsenic and other areas. So the pipelines are actually the pipelines of the life of the people down there. But my lord, at the same point of time, we are not in a position to say that we will not make good to what has happened to the petitioner, my lord. That is the stand of the state, my lord. So my lord will kindly direct respondent number 8 in the presence of 7 and 9, my lord. And the petitioner, of course, my lord.
Whereas once upon a time that has been done.
Where is that demarcation report?
My lord, from the report, they have annexed the documents. However, my lord, for the sake of the my lord,
demarcation not done.
And there is no report from the state. There is a report.
Yeah, demarcation
In
fine.
this
It is
matter,
normal.
report?
মানে আমরা যে নিয়েছিলাম সেই point.
What type of my lord, the operation is needed, my lord, we shall help because admittedly they are stated. Yes, they have stated in their PDP that the major portion has been utilized by the PWD Purvo Medinipur of their own report. They seek
Where is the report that you are referring to?
My lord, it will appear, it has been affirmed by one Devashish Chattopadhyay, the report in the form of affidavit filed on behalf of the respondent number 7. 7 was there, yes.
No, it's not fine.
Yes, there is a report.
Somehow
Para 4 onwards, my lord, left here. And 8, they have admitted that. Para 8.
Yes, it has been done already. You have a
the
copy of
demarcation, the physical demarcation has not been done.
paragraph 8.
Is that on
Paragraph
8.
that on 5th April 2023, the concerned BLA Laro Contai 3 issued letter filed with Sati said to assistant engineer Contai subdivision PWD encroaching inquiry report as submitted by the revenue inspector and hand sketch map in respect of the land in question, showing the location of the pipelines as installed in some portions of the land in question as involved in present petition, and a major portion has been utilized by the PWD.
My lord, here what has happened is the BLRO has gone ahead and perhaps created a prima facie inquiry report, my lord. But the difficulty is that it has to be done demarcated physically as well as in terms with the records. Until unless
Respondents are responsible. The court will not give a further direction.
my lord,
You have
will
only
kindly
to-
direct
no,
the
no,
BLR.
no.
My lord, we are standing in the
9 and 10.
my lord, as my lord, I am representing the BLRO, my lord. I am seeking the direction, my lord. It will help ease out the crease, my lord.
Perhaps contrary, but it will create some problems also. Now the new video, I don't know whether I'm
My lord, I also do not know whether
the
the BLRO then BLRO now.
Doesn't show a clear demarcation.
It does not.
With reference to the Moja map, etc., the dark numbers and the quantum, earlier report doesn't show all that.
And can see paragraph 9 and 10 of the report.
So this is what I'm saying.
There is some confusion and he wants to file a further report. So let there be a further report in presence of both the parties.
My lord, let
So
the
that
respondent
will
number.
solve the issue,
My lord, let the respondent number 8 prepare the report, my lord.
but it will
With
be
the-
on your prayer.
My lord, let it be. I don't mind. My lord, and there be direction of field inquiry in the presence of 7, 9, and the petitioner.
Learned counsel for the respondents submits that the block land and land reforms officer,
Principal secretary আমাকে বলেছে টাকাটা দিয়ে দিতে চাই।
being the 8th respondent herein, be directed to demarcate the plot in question in order to ascertain the quantum of land of the petitioner utilized by the respondents, and the exact location of the pipelines laid. Paragraph. In view thereof, comma, the eighth respondent is directed to demarcate the plot in question in order to ascertain the utilized portion of the same and the quantum thereof, comma, in presence of the petitioner slash his authorized representative and the seventh respondent.
Respondent number 7 and 9. 6 also might be, I don't mind.
Because he submitted the report.
As well as respondent numbers
6, 7 and 9.
6, 7, and 9, and submit a report before this court on the adjourned date. Paragraph, let the matter appear under the same heading on 3rd October.
My lord. Obligement. Obligement.
I in presence of petitioner here. Can you remember that matter, my lord? Where, my lord? Is there property? Is there
Respondents?
respondents have all they had been appearing several times. Today my prayer would be for a adjournment, my lord. But because
It is under challenge.
my lord, kindly remember, my lord, there is I have filed my supplementary.
Yes, it
and
is
taken
there.
My supplementary affidavit.
I cannot hear it out in absence of the respondents, isn't it?
I'm not. No, I don't press for. I am pressed for adjournment, but because of section, I have filed in section 34 of the Trust Act because that is the involvement. Because my property, there is the trust property, and there is a taboo, my lord. Unless and until section 34 is disposed of, because they are willing to, my lord, for direct purchase, my lord. But they have stated in their impugn order, my lord, impugn memo, that unless the district judge, that is impugn memo.
That is still pending. It is pending before the district judge.
So, my lord, I'm praying for some adjournment. Let the matter appear in the monthly list of November, my lord. I suppose the difficulty.
None appears for the respondents.
The supplementary have annexed, my lord, section 34 and other.
Paragraph. Learned counsel for the petitioner seeks accommodation on the ground that the application filed by the petitioner trust
Yes.
for permission to sell out the land in question is pending before the learned district judge. Paragraph, let the matter appear in the monthly list of November 2023. November.
District judge Paschim Bardwan.
District judge Paschim Bardwan.
This case number 39 or 20.
District judge Paschim Bardwan.
Twenty-three, my lord, on last occasion, lordship directed me to file a fresh wakalatnama as the my lord, notice, administrative notice has been issued in the name of the petitioners.
Yes.
But the difficulty is this, my lord, one of the son of the petitioner, he is in my contacts, but he is presently out of India, my lord. And for that reason, my lord, I am unable to get a fresh wakalatnama, my lord.
But kindly make the matter out of list, my lord. Otherwise, it is very difficult for. Yes, my lord. Yes, my lord.
Let it be out of list.
Yes, my lord. And liberty to mention, my lord. Give me a liberty to mention.
Liberty will automatically be
My
there.
lord. What is this?
The petitioners seek further accommodation. Paragraph, let the matter go out of list.
I'm the list.
24,
But
petitioner.
I seek your indulgence, Mr. Persistent. But there was a report filed by the state, Mr.
Yes.
That report somehow misplaced from my file, Mr. I need a copy from the state so that I can come back, Mr.
You wanted to use an exception. You wanted to use an exception to the report.
Let us first go through the, if required, I shall file it.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 25th September.
September.
25.
Lord, I am for the petitioner. my lord. রিপোর্টের কোনো স্টেটাস আমাদের কাছে স্যার এনেই চেক রিপোর্টটা আছে ও আচ্ছা আচ্ছা এনেই চেক
Yes, there is an exception.
exception yet to be, my lord, affirmed. Yet to be affirmed, my lord. My lord, kindly sees, my lord, only one thing, my lord. My
You don't
prayer in
have
the
time.
my lord,
Without the exception, you make your submissions.
my lord, no, my lord. My lord, I cannot, my lord, since my lord, I am, my lord, exception, my lord. I'm without instruction in this regard, my lord, whether it cannot be done, my lord.
Earlier date also you sought extension of time.
But my lord, it can be, my lord, disposed of without an exception, my lord. Kindly, my lord, takes up, my lord, the contents of my writ petition, my lord. My lord, I have only sought, my lord, in this writ application, my lord, not anything regarding to the arbitration proceeding, my lord. My lord, I have accepted that, my lord. If I am, my lord, aggrieved by the quantification, my lord, I have to approach another forum, my lord. I am only, my lord, on the fact that after the rate has been increased, reassessment of my compensation is to be made. The amount that which I have got, my lord, that is to be reassessed, and my lord, a fresh award, my lord, has to be published. Kindly takes up, my lord. Kindly, my lord, takes up page 22, my lord, of my writ application, my lord. This is the arbitration award, my lord. Starts at page 18, my lord, kindly comes to page 22. My lord, I fall under, my lord, lordship has found, my lord, from the bottom, my lord, hence it is ordered.
Yes.
I am, my lord, I am on the, my lord, I fall under the first category. The rate of body BT class of land will be taken as, my lord, this amount per acre instead of the previous rate.
So in terms of this, you say that it has not been reassessed.
Not been reassessed. That's my prayer, my lord, in the writ application, my lord.
This has to be done by the competent authority.
My lord, but my submission is lordship, that should be, lordship, they have to take the record lordship before section 32.
Why?
It will be part of this award, my lord. My lord, the
I've accepted the
calculation
award.
part, my lord, it is the only way lordship to avoid the section 34, because he said he accept the award.
Has
If
the
he accept the award, lordship cannot be agreed with this calculation.
has the award been complete? He is not agreed with the calculation. On the basis of the arbitral award, a fresh award has to be declared by the authority. Where is that declaration?
This is the lordship, this is the award. If he has been agreed,
This is the award, but the award has to be reassessed on in terms of the arbitral award.
No, this is the enhancement.
Award. It says that it will be taken as such and such per acre instead of such and such.
yes, my lord.
So taking it to be 30, this 36,
My lord,
this
who
figure,
will do this, my lord?
the competent authority,
Well, a competent authority cannot reassess his own calculations, my lord.
not
As per section
reassess.
361.
It is not reassessment. The award is not complete. Award has to be completed. Where is the copy of award given to the petitioner which shows the reassessed amount? After an award is passed, a copy of award is given to the petitioner, showing the finally reassessed amount. If the petitioner is agreed with that, where is that part of the award? Please show me.
This calculation, Lordship, he has.
Where is the calculation? I do not find any calculation. Petitioner is not supposed to.
Section 34, Lordship.
No, not at all. Where is the copy of award given to the petitioner?
That, Lordship, I am not the custodian of this, my lord, the document.
That's why I think submission has to be made by the state. Because you have deposited the money, your part is over. Yes, Mr. Mantrapati.
What is his application? When the award has been formally ordered, what my learned can show your lordship, page 22.
Yes.
That order was by the arbitration on 14th October 2015.
Yes.
And he made this application.
Well, there is a delay, my lord, but that cannot, my lord, take away, my lord, my right, my lord,
And my
to
lord,
my
that delay cannot be explained in this.
my lord, this is my lord, only thing, my lord, consider, my lord,
He has accepted the
my lord,
application.
yes, I have done so.
And after 5 years, he has made this application in order to award the.
স্যার আমি অ্যাওয়ার্ডটা
Section
চ্যালেঞ্জই
34
করছি না, আমি অ্যাওয়ার্ডের বেসিসে আমার বেনিফিটটা চাইছি।
Where is the copy of the award that you have sent to the petitioner? Please show me.
And let me someone take instruction to that effect, whether the final, after that recalculation.
Because this is not a
whether
calculation.
it has been submitted or before or not.
This is an assessment made by the arbitrator. The assessment has to be finalized by.
Your lordship, kindly turn to page 1.
Page 14, my lord.
Page 14, P1 of the
Yes. This is the record of rights.
record of right. পত্রসত্ত্ব দখলকারের বিবরণ, নাম দীনবন্ধু পাল, is the petition. Tag number 3131, 3132, 3145. জমির শ্রেণী P2. মন্তব্য ডিজেল পাম্প। What is this plot number? Paragraph 2. 1496.
Can you make this submission after the arbitral award has been passed in his favor?
His statement, my lord, he is stating that the petitioner by virtue of petitioner became the owner of such and such. Plot number 1, he is a petitioner nature, he is running the petrol pump. That has not been assessed. He has not never stated that. Yes, annexed the documents, record of right.
My lord, kindly takes up page, page 5, paragraph 9 onwards, my lord. রিপোর্টটা আপনার রিপোর্টটা।
Yeah, that's why my question was that you have to serve a copy of the award to the petitioner showing the enhanced amount. If at all limitation starts, it starts from that point. So when have you served the copy?
Order, my lord.
My lord,
22.
Yes.
The rate 1, 2, 3. Hence it is ordered. Hence it is ordered that 1, the rate of body plus factor. Well, it is the rate of token. That is the commercial. The token will be allowed 80% of body plus the rate of token is taken up 59,55,245 per acre instead of 30 lakhs. Therefore, it has been enhanced.
My lord, kindly,
given to him.
my lord, kindly comes to the last line. Let this order be communicated by the competent authority at NHA and ADM to all concerned for information and compliance.
That is what exactly I'm on. That is exactly what I'm on. The last line of the order has not been, that has to be complied with. This is the assessment given. On the basis of assessment, there has to be a final calculation. final
My lord,
copy.
141 petitions were disposed of by the single order, my lord. After that, my lord, it has to go back to the competent authority, my lord, and
And
my lord, I'm not, my lord,
Question, Lord, you cannot explain anything in the delay, my lord.
he is not supposed to know when the order was passed.
and moreover, my lord,
So
delays,
please show me
my
the
lord, if I,
communication of the order.
my lord, if I challenge the order, my delay, my lord, that part will be taken into consideration.
Arbitration proceeding has been initiated. He is aware of this fact.
Arbitration
After 5 years,
proceeding is
without
over.
any explanation of this delay, my lord.
After 5 years of what? When did the petitioner receive the copy?
He is aware of this order, Lord. That should be in the, it must be in the averment, in his writ petition.
And my lord only considers, my lord,
No,
only, my lord,
but
only, my lord, one
because
submission.
there latches
No,
by
my lord,
like
that is-
this.
If there is any latches, Lord, that is
There
our part.
is, there is.
My lord, only one humble submission, my lord, the delay, if there is, at all, my lord, if there is any delay, that would be considered if I challenge the award. My lord, I'm not challenging, I'm accepted. I just want my compensation,
He is asking for implementation of.
implementation of the award,
That's
my
all,
lord.
nothing else. Award has not been implemented in terms of the arbitral award. It is submitted on behalf of the petitioner that though arbitral award was declared on, what is the date? 14th October 2015, comma. No fresh assessment of compensation has been made by the competent authority in terms of the said award
Award টা date এটা না দিদি?
awarded as
14/10/15
award and such assessment or copy of award.
My lord, the award is my lord 14th October 2015.
Yes, I will not.
My lord, my lord, my lord,
Yes.
my lord.
And also was not served upon the petitioner, has not been served, has not been served upon the petitioner till date. Paragraph, learned counsel for the.
My lord,
Yes. Why shall he apply? It is his entitlement.
Oh, my lord, not it, not it.
Please see the last line of the award. It has to be communicated.
Whether he has applied for, my lord.
Not
I'm
necessary.
asking myself, my lord.
Not
He has
necessary.
applied for.
Not
It's
necessary.
stated
Please see the last. Once an award has been passed, it has to be communicated. Page 22, last line of the award. Page 22, last line. This has not been complied with. Paragraph, learned counsel for the respondents seeks to take instructions in this regard. Paragraph, let the matter appear under the same heading. Simple issues are made complicated by the government. I'm sorry to say
No,
this.
my lord, I'm not completed. If it is not supplied, then let it be.
He has to know the exact assessment of compensation made in terms of the award. He doesn't know that.
Yes, according to you.
25th September.
Grateful, my lord.
What is not?
Twenty-six.
26, my lord, adjournment is to be, my lord, sought. Since, my lord, the same issue is pending before the division bench, my lord. It's related to, my lord, long-term lease of, my lord, the coal mining, my lord, under the Minor Minerals Act, my lord. In respect of the same plot, my lord.
That's recorded in the earlier order.
Yes. My lord, that's pending, my lord, in the monthly list it's pending, my lord.
November. Yes. In view of the order passed on 11th July 2023, comma, let the matter appear under the same heading in the matter list of November 2023. November. No? 27.
7, my lord, Didi, 7.
27.
Well, I am appearing for the private. There are several 8 to 10 private respondents I am representing.
My lord, I am, my lord, for the petitioner, my lord, kindly, my lord, gives me a time. My lord, I am not ready. My lord, Mr. Roy, my lord, is leading me in this matter, my lord. It's to our point.
Lordship will kindly fix a date because this is pending from 2020.
On prayer of the petitioners as well as the state respondents, a petitioner is good. Statement.
27.
The matter is adjourned. Paragraph, let the matter appear under the same heading on 25th September. 25th September.
What is the private?
The petitioner seeks accommodation.
26 September.
25th September.
March.
28.
My lord, I beg to appear for the petition.
Yes.
The matter was heard at length, my lord, but then since there was a change of the panel and nobody. Yes, my lord, we have served. My lord, my affidavit of serve.
Yes. Please switch on the microphone, madam.
My lord, I'm for the state led by Mr. HON'BLE.
Yes. Mr. Dev was here just now.
My lord, he's engaged in court number 5, my lord.
My lord, my affidavit of service be kept.
There was a submission on the earlier date that the road is complete.
My lord, the submission was made by the state government, the erstwhile advocate who is appearing, my lord. Now, my lord, it was my lord's wish that what is the status of my matter before the learned civil court that I was to appraise my lord of. So, my lord, my injunction application is pending, but that is inter se the parties who are the owners of the various plots. Inter se the party means my brothers and myself, my lord. And this particular road, we had made the state a party. This petition was because the road was a private road, which was made concrete. And we were using when it was a Kacha road, it was used for us to try as a road. But then we also used to use it for small cultivations. Now, my lord, when this road is going to be completed, my lord, initially when the writ petition was filed, it was not completed. There's a report before my lord which says that it's still going on. But with the rigmarole of events, my lord, because of the intervening pandemic and everything, now it had been stated at the bar by the state representative, my lord, that the road is complete now. My lord, my writ petition is this, my lord, that on a private road, my lord, it is a private property where a civil dispute is pending. Now the government has made a road on that, making it totally concrete. Whereas I, being a rustic villager, I used to use a portion of that land for cultivation of small crops, which were used for my own consumption. Now, my lord, but during the pendency of.
That road part of your property.
Yes, my lord. Yes, my lord. Yes, my lord. Let the state government come and say that it was a public property. I'm out of this court.
Today, I believe Mr. Day is not available.
My lord,
Please
we'll fix
contact-
up a date, my lord, next week, any day, my lord. Let him be available, my lord. Because this was what was going on. In the meantime, the panel changed, my lord. Again, it has been.
Yes, yes. Affidavit of service. Paragraph on prayer of the state respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 26th September.
I'm grateful, my lord.
I don't know.
I'm grateful, my lord.
29.
My lord, I'm for the petitioner. I'm kindly praying for 2 weeks of time.
Mr. Bandapata for the respondents. Petitioner is not interested in the matter. Earlier occasion, you did not appear at all.
No, my lord, actually.
Please be ready on the next occasion. Otherwise, it will get dismissed.
Sure. Yes, my lord.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 29th September.
Obliged, my lord.
30. Yes, anyone for the petitioner in 30? None appears for the petitioner, no accommodation is sought, dismissed for default. Yes, Mr. Mondal, you're all right now? 31.
31, my lord, I am paying for 1 week accommodation, my lord, on behalf of the petitioner.
Why?
Lord, Mr. Arif Ali is appearing, my lord, he instructed me to take adjournment because, my lord, he needs some instruction from the client, my lord.
Sir, the report already submitted.
Submitted already?
Lots.
Should it be now?
In pursuance of your lordship's order, my lord, already compliant with the.
This is not in the form of affidavit.
Lordship already sent the judicial secretary sent to the
The
district judge.
petitioner is not aware of the case at all. Report submitted on behalf of the state respondents is
Copy.
taken on record. Paragraph on prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 29th September.
20. The report is kept on record.
My lord, kindly direct them to give me a copy, my lord.
Mr. Mondal, please serve a copy.
এটা একটা জেরক্স করে
আমাকে দিন আমি দিব।
ফোন নাম্বারটা নিয়ে নাও একে দিয়ে
29. Two. It's a part. Yeah, it's a part 5. Petitioner? Anyone for the petitioner? 32. None appears for the petitioner, no accommodation is sought, dismissed for default.
My lord, my humble submission is that since we have no instruction, there is no instruction because they reside in the bordering area of North 24 Programs and some mishap has taken place just 3 days back. So kindly put it in the monthly list of November. It will be highly appreciated because there's some family problem in there due to this mishap.
On prayer of the Mr. Bandapathy in this matter.
Grateful, my lord.
On prayer of the petitioner, the matter is adjourned. Adjourned and
Kindly put it in the month of December, my lord. That will be most convenient.
on prayer of the petitioner, let the matter appear under the same heading in the monthly list of November 2023.
Grateful.
34.
My lord, I am for the petitioner. My lord, as per your last order, I have served at the office of the GP.
Yes, have you served?
This is the affidavit of service. Probably no one appears.
No.
Mr. Bandapathy, may I request you to appear? It has been served. Please serve a copy to Mr. Bandapathy.
My lord, I am aware.
Yes, what is the matter about? Let us hear what it is.
Matter of the 12th August 2021, this court passed an order directing the state to take instructions. My land just beside the State Highway 1 was to take by the state authority, highway authority, for the widening of the road. That was the matter. Without giving prior notice to me, they demarcated and marked my portion of my shop. So on 12th August 2021, Lordship directed state to take instructions. No instruction till date has made before this court.
And no further step has also been taken by the state?
A portion of my land has been taken.
You have a representation pending?
Yes, my lord. Kindly see 46, page 46. My last representation dated 24 July 2021.
Shall this be considered without wasting further time? Or you want to wait for instructions of the state?
My lord, I want the consideration of my representation dated.
He says that his land is being encroached upon without acquisition. Yes. Should be by the special land acquisition officer.
No, man, their allegation against the West Bengal Higher Development Authority. They are the encroaching the lands of the people.
So third respondent.
Let them decide whether it has been demarcated.
So third respondent.
Third respondent.
Affidavit of service. None appears for the state respondents despite service. Mr. Bandapadhyay, appointment regular school. Copy service and direction. Paragraph. The petitioner claims to be the recorded owner of the plot in question and alleges that a portion of his plot alleges that the state respondents are encroaching upon a portion of his plot for extension of Chagda Bonga Road without acquiring the same by the process of law. So the petitioner submitted a representation to the concerned authority in this regard on 24th July 2021, which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph. It is submitted on behalf of the state respondents that the third respondent be directed to consider the representation in accordance with law. Paragraph. In view of the above, the petition is disposed of directly to the third respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 1 month. Within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner, in accordance with law. Paragraph. The decision taken by the petitioner shall be communicated, authority shall be communicated to the petitioner within a week thereof. Disposed of which.
Obliged, my
1
lord.
month and 1 week.
Obliged, my lord. My lord, the representation dated 24th July.
I've recorded. I've regularized your record.
আমি আপনাকে কপি
Junior, along with learned junior officers. That call.
Obliged, my lord.
Next.
35. 35 minute up for this.
Petitioners? No one? Dismiss for default. No one is appealing.
Or should I appear on behalf of the petitioners? The learned advocate on record is indisposed today, so kindly makes it. I'm praying for an accommodation.
It's taken by you. Please be ready on the next occasion. On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 29th September.
Grateful. Your Worship.
29. Next week.
My lord, I am paying not today.
Yeah. Yes,
Not today, my lord. My lord,
even if the matter is called, it is being adjourned.
yes.
37.
Do not want to be in such matter.
Because it's very embarrassing for you also.
Very embarrassing for me.
My lord, since inception, my lord, Mr. Tulsinath Maiti is appearing, leading me, my lord.
कोर्ट के ना बोले कोर्ट के
My lord.
very embarrassing.
My lord,
for
my lord,
the-
my lord.
You yourself should settle this.
My lord, I am the recording advocate, recorded. Pradeep Kumar Ghosh, my lord.
The interest of the client should be of prime importance.
My lord, file it, not today, my lord.
Not today. Whether a problem will be solved by a course of day.
On prayer of the petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 29th September.
In the meantime, my lord, if I can settle the matter, or the client can comes to me with to sort out this matter, I'll be appearing. Otherwise, my lord, kindly excuse me. I did not.
Manas,
Next.
same here, my lord.
Next matter is same, identical. 37 and 38.
Same order.
Same one.
My lord, Mr. Bandyopadhyay was first state in this matter. Item 38.
Is for the state. 38 session was.
$39.
Not for the petitioner, my lord.
29.
$39.
Can also.
Time, Nilo.
For the ECL, who is appearing?
My lord, they have not filed in a report for last 5 times, my lord. You have lordship granted.
It's granted. Who is appearing for the ECL?
My lord, 39 ECI, my lord. No.
Can we hear out the matter in their absence?
No.
My lord,
They are the answering respondent.
my lord,
If the answering respondents do not answer, the court cannot help them.
My lord. Last
but my lord, I will
occasion they
submit a
appeared.
judgment before lordship in the similar facts and circumstances, my lord. If your lordship kindly consider that and then direct, my lord. Otherwise, neither they are filing in a report, not they are appearing, my lord. Sometimes they appear, sometimes they do not appear. My lord, last time they said that it was the last chance. 5 times they have been granted time to file a report, my lord. नाम लिख दो।
You are seeking employment as a land.
Yes, yes, my lord. But if your lordship kindly allow me to submit this and you put a judgment, my lord, silent. না 37 38 39 আলাদা মানে যেটা বলছিল ম্যাডাম জিজ্ঞেস করো 38 38টা বলছেন উনি 38 বলছেন উনি My lord, in this order sheet, my lord, everything is covered, my lord. Same issue, my lord. They are the land loser, my lord. They have been considered. It's
But
not
here
that
the
in,
land was taken away prior to 1984.
yes, my
In
lord.
your case?
Issue remains the same, my lord, because in my case also, my lord,
Land taken away. In your case?
my lord, in my case also, my lord, issue remains the same because they are taking this point.
When was the land taken away?
I'm telling, my lord, I'm telling. Land was taken, my lord, on September 1973 to November 1973, my lord. It was used, my lord. Therefore, it was purchased later on, my lord. My lord, there are letters which shows that they have been directed to police verification had been done. Everything had been done, my lord. Later on, it was rejected. My lord, page 27, my lord, annexure P5.
I'll just make it not today. Please inform the ECL in the meantime, otherwise I'll take it up in their absence tomorrow. If they do not appear
My lord, tomorrow, my lord.
tomorrow. I'll just make it not today. Please inform the ECL. Who is appearing? Mrs. Shonchita Bormon Roy.
Yes, my lord.
Please inform her today if you can.
I will, my lord.
Inform her that it will be taken up tomorrow, whether she is there or not.
Can kindly keep it on Wednesday so that I can get a time one day. Otherwise, if I do not get them today, by any means, then my lord,
Very good.
because if she doesn't come or anything, kindly keep it on
None
Wednesday.
appears for the Eastern Coalfields Limited. Paragraph, let the matter appear under the same heading on it come up on 11th.
11th.
Paragraph, it is made clear that the matter
11th.
shall be taken up for consideration on the adjourned date, even in absence of the ECL.
My lord, he's giving her at 11th.
11.
I'm just saying it on 6th, my lord, because Wednesday.
I have recorded that it will be taken up even in absence of the ECL.
All right.
Serve them with sufficient notice.
As your lordship does, as your lordship does. My lord, please keep this record, my lord. What order sheet, my lord, kindly keep it in your lordship's record, my lord. I have just submitted it.
On record.
On the
40. Is there?
I appeal for the petitioner. But on the last occasion, Lordship's desire was that the plot of the petitioner be demarcated, measured and demarcated. Lordship, on that basis, my lord, a report has also been filed. So what I find, my lord, the report is definitely faulty
No, Lordship, there is no fault.
because, my lord, the measurements,
Will you make your submission simultaneously, or will you allow the petitioner to complete his submission first?
No, Lordship, I am.
Lordship kindly takes the report, my lord, and where the sketch map is there, which is, I think, page number 1, 2, 3, 4, the 5th page. This is the sketch map which has been prepared by my learned friend.
You say that the 80 feet of land has not been physically demarcated. That is
Lordship,
your case.
because not only that, my lord, they have said that 65 feet, Lordship will see, it's a triangular plot of land. In diagram A and diagram B, the two arms, 65 feet and 68 feet, they remain same. But the frontage mysteriously varies.
Please give me a minute.
The last report, Lordship, would find that 17th February 2023 dated.
Several exceptions are used.
No, Lordship. The last report, there was no exception, Lordship. They did not file any exception.
None of the reports are on affidavits.
No, my lord. None of them are at affidavits. It's on a letterhead.
First report will do this by affidavit form.
17th February report you're pointing.
17th February 2023.
In
Yes.
presence of the petitioner lordship.
Lordship will take
Why are you making a running commentary, madam? Yes, page.
Lordship, the 5th page where the diagram is present. Lordship, the petitioner's plot is a triangular plot.
You mean a sketch map?
The sketch map, my lord. The petitioner's
Map. Yes.
lordship. The orange marked portion, that is the petitioner's plot. Lordship will see in both the diagrams A and B, the two arms, my lord, 65 feet and 68 feet in both the sketch maps.
Yes.
However, my lord, the frontage in one is 63 feet and the other is 67 feet. So first of all, my lord, if the two arms remain same, the frontage cannot vary. If 65 feet and 68 feet, they are same, the frontage,
65 and 68 be the same.
no, 65 feet and the other arm is 68 feet. In both the diagrams, Lordship will find 65 feet and 68 feet.
Yes.
If these two remain constant, my lord, the third, which is the frontage, that cannot vary.
Take 67.
In one, it is 67, in another, it is 63. So, my lord, it is definitely, Lordship, the measurement is faulty. It cannot be same. If the frontage is decreased, that would mean that there has been encroachment. The other arms would also vary. 65 would decrease, 68 would decrease, and the overall land would decrease.
Not 63, they say 83. In one, the first,
The first. Lordship, I'm
isn't it? It's 83 and 67.
it is 83. মৌজা ম্যাপ অনুযায়ী স্কেলবিহীন হাত নকশা, and this is মৌজাতে প্রস্তাবিত দাগটির বর্তমান অবস্থান অনুযায়ী স্কেলবিহীন হাত নকশা. So, my lord, if such a difference cannot be, if the two other lengths, the two other dimensions remain same
What is as they have
found. So there definitely has been an encroachment,
is the Moja map.
Lordship, as per the Moja map.
You were present when the measurement.
I was present, my lord. And but these maps were not prepared in my presence. These were prepared subsequently. Lordship, the dispute would be resolved, Lordship, if the BLRO would go once again and only demarcate this 83 feet.
You want to raise a boundary wall.
Lordship,
around
Lordship.
surrounding your property.
For that reason, my lord, only this 83 feet be demarcated to us. Lordship, we shall raise the boundary wall and this can be resolved once and for all. Lordship may direct the BLRO for the last time.
What the state has to say. Yes. How do you explain the difference?
Lordship, there is a
Take the microphone, please.
Lordship, kindly came to the page. Report A, report B, Lordship. Kindly came to the
What is
annexure B, annexure B, Lordship. As per the CLR, as per the CLR of the CLR is found that the plot number 20 is classified as Danga and measuring of area 0.05 decimal. And during the measurement, it has been found that at present of the applicant, the Sri Mongol Kumar Bhaumik is possess of 4.41 decimal of land, and the rest portion, that is the 0.59 decimal of the land, is beyond his possession. It is totally a rayati dispute, Lordship. It is totally a rayati dispute, and the government of West
I'm
Bengal
not on
is
area.
not at all involved in this matter. The hand sketch map is of the shoot plot has been prepared accordingly to and accepted to the same, the respective. Lordship, this is the rayati dispute between the adjacent plot, Lordship, not with the state.
I am not
PWD.
going into the area, my lord. I'm only concerned about my frontage. If the frontage is shown, my lord, the rest I can.
The first map you show.
Yes, Lordship, I see.
So
Lordship.
how do you explain this difference?
Lordship, then again, the BLRO will satisfy it by demarcating the first. This is the triangular plot. One is 83, and there is 67. What is the difference between two?
But I think the second map is the present situation.
Yes.
This is the present situation, and our allegation in the writ petition is that the road has been constructed encroaching my plot of land. That is why, lordship, if and they say that there is no encroachment. Similar, that is why they let them demarcate the 83 feet of.
Area has not reduced.
If this map is to be taken here to be true, lordship, my area definitely they have encroached.
Area is 20 square feet or whatever it is.
Around 40 decimal. Lordship, the entire lordship.
4.41
Everything
decimal.
will be resolved if the 83 feet is measured and they say that this is the point A and point B. Lordship, I shall have my masons present. I'll raise my boundary wall. Lordship grants me that liberty. I think this is the last exercise before the writ petition comes to an end.
Your 83 feet, and this will probably not be the concern of the government, because it is really a private dispute, as learned counsel points out.
There's a private dispute or with respect to the adjacent plot owners.
Increasing of the frontage is with regard to the adjacent plot, which is 21.
Yes.
Lordship, if that be so, my lord, in that case, my lord, that is why I said as per the Moja map, if the 65 feet and 68 feet remain same, my lord, and in actuality also 65 feet and 68 feet remain same, my lord, then the frontage will also have to be, lordship, it has to remain same.
The frontage is differing because of, now see, it's
Lordship.
this way. Yes, and the government land is the green part.
Is the green part. I am not.
Whether your frontage
I don't have the green part.
just adjoining your orange part.
Lordship, I've got a Xerox copy, so the colors are not there.
The pathway. Just adjoining your plot. Yes. Your plot is a triangular plot, isn't it?
Lordship.
The frontage, as you call it. Just
So once the frontage decreases, my lord,
frontage has nothing to do with the government lot.
but
As
the
it
green,
appears from
the
this.
green one is the government road, my lord.
Government road is the entire thing is government road.
Yes.
Your frontage is increasing or decreasing due to the next plot 21.
21. Yes.
If 21 has encroached, my lord,
So 21 is a private plot.
yes, if 21 has encroached me, then in that case, 68 feet ought to have diminished.
Now,
As per Moja map, it is 68 feet.
68, yes. Because
If they encroach, the 68 would reduce.
No, earlier it was
68. As per Moja map.
Petitioner also engaged
earlier
to
it was
Amin's Lordship.
83, not 68. Please see the left-hand side
Lordship.
indications. The triangle has been showed there. It was 83, not 68. 83 feet.
Yes.
And then it became 67 feet.
Lordship.
So this reduction is due to
Lordships,
By
if as per them it is 21.
Yes.
So if 21 has encroached upon this land, Lordship, the length of the other arm, Lordship, which is 68 feet, which is shown in the first sketch map, and in the second sketch map also it is 68 feet. Lordship, if there is encroachment, the arms cannot remain same. It has to reduce.
No, this is.
If it is a triangular plot, it has to reduce. If it is a square plot, it would have remained the same.
Has nothing to do with the government encroachment.
Lordship, that is why, my lord, let them measure, my lord. I shall.
Government will not demand.
Lordship, I will not. Lordship will not entertain any private dispute, my lord. Only let them say that the 83 feet would have been here. Then I can, if they say that 21 has encroached upon.
They will not say that. Why will they say? It's not their responsibility. to
Let
say.
them not say, my lord, but let them say that this is point A. Point A and point B, let them say that.
Your
The
the
next
removal
page-
of unauthorized construction from your land by the respondent authorities.
Lordship,
Where is the unauthorized construction?
Lordship, the unauthorized construction, Lordship will find there was a boundary wall previously. And Lordship, I kept this land as it is. Suddenly I came to know that my boundary wall has been demolished and several materials had been kept in my plot of land. Lordship will see the photographs in the writ petition, which is at page 45 of the writ petition. This is my plot of land. It is full of building materials. Lordship will see a JCB, iron rods. These were used by the respondent authorities for the purpose of construction of road. They demolished my boundary wall and entered into the
Time of joint field inquiry?
Lordship.
Did you state this, point this out at the time of joint?
No,
field
Lordship,
inquiry?
Lordship, this has been the case from for day one.
Has it been recorded?
Lordship,
Where is your field inquiry report? Where the submission of the petitioner is also recorded?
Lordship, previously
no, there is no submission which was recorded by them.
Lordship, let I file the affidavit in opposition, Lordship. Full form.
It will be.
was also
It will be resolved.
At the time
Let
of
them show
demarcation.
point A and point B where my boundary wall used to remain, my lord, where they have, in my submission, they have constructed a road. If they say that this is the frontage which I should be claiming, Lordship, I shall immediately, Lordship, that will end the writ petition.
Said already, a further report will not add to anything.
They have, Lordship, the report is faulty.
No, there is no fault.
They have shown a reduced frontage.
Show a continuous boundary of their path.
Yes.
Yes, so a report cannot be called faulty. If it is faulty, it is due to encroachment by the private parties, not the government.
This
The
by
frontage has nothing to do with the other encroachment. And they have said where is this recorded? 4.41 and 0.59? Yes, Lordship. Does not be referred in your sketch map? It's 4.41 and 0.59?
it has not been
Have you
referred.
shown that in your sketch map?
No, Lordship.
So
It is
then
not
how
in
can
sketch
you, how can you make out? Why don't you come back on affidavits?
Let them show this on my lord, by way of an additional report.
No, Lordship.
Lordship, we can thereafter come back.
Additional report or a full-fledged affidavit? Because
Affidavit,
factual
Lordship,
issues are there. Let them come back with all the documents.
Lordship.
Lordship, two Amins was engaged by the petitioner, Lordship, at the time of demarcation. Next page, Lordship,
Where is
kindly
the
see.
report
Next
of your
page.
Amin?
No, I mean, there was no direction on me to file any report by the Amin.
So your other did not go
This
for a
is to
picnic
inform you
also.
that
You
Mongol
have done
Kumar
something
Bhowmik hereby engaged
Lordship,
two
I
others.
have to check that, my lord.
So why don't you take instructions and come back? I'll adjourn the matter.
Lordship, I can do that, my
A
lord.
separate report has been prepared by your, that should have been done.
I shall inquire, my lord.
Come back to the supplementary affidavit.
It keeps it,
Ramji was present along with the state people.
there shouldn't be any difficulty.
Yes.
But it keeps it 2 weeks hence, my lord, I shall.
They already engaged two.
Exception you're filing today?
No, my lord, I have filed much.
Filed earlier. Her learned counsels for the parties. Paragraph. It is submitted on behalf of the state it is not in dispute that the joint field inquiry was held by surveyors appointed by the state as well as the petitioner in presence of both the parties. Stop.
Sketch map be sealed and signature by this Amin at the sketch map.
Which Amin? The petitioner's Amin?
Petitioner's Amin, Lordship.
Sketch map.
Yes. Jasimuddin Mollik.
A learned counsel for the state respondent submits that the sketch map appended to the report is signed by the Amin appointed by the petitioner. Paragraph, learned counsel for the petitioner seeks to take instructions in this matter. Paragraph, let the matter appear under the same heading on 28th September.
Lordship.
28th September.
28th September.
But in my matter, today's interim order is expiring today.
Which matter?
819.
Yes.
819. 819.
Have you mentioned for extension of interim order? No.
That is tomorrow, my lord. Today
This is not the mentioning time. You should have mentioned earlier.
matter is in the list. My lord, I was stuck up.
Please take up the matter. Matter is in the list.
I was stuck up just. Number one.
Is it a kalke reference for extension of interim?
Lordship,
My lord, may I say one thing? July.
I have not called any matter, madam. This is not the mentioning time. Please do not
Lordship,
mention matter.
item 8 and 19, we are not received service, your Lordship.
8:57.
He has not come.
My lord, this is a short matter, my lord, for consideration. Last to date, it was adjourned.
Come back, Mr. Sen is not there. He is generally here. On prayer of the respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 13th September.
My lord, one copy of the order I am handing over to the learned advocate. My lord, may kindly be recorded in the order, else I have to take this.
No, I cannot record that. Come back.
My lord, in the
Copy of some order.
my lord, one order, High Court order copy I am handing over to my learned friend, my lord.
Come by way of a supplementary affidavit, then you can hand over. You're just handing over informally. You can hand over, I cannot record.
My lord, then supplementary affidavit I will file. Grateful.
8:58.
My lord, in this matter, I am appearing for the petitioner, my lord. As per your lordship's last order, my lord, I sent copies and they have received.
I am appearing on behalf of state respondents. I am led by Mr. Bandhavat.
And what about the private respondent?
My lord, they have received.
Seven respondents.
Twice, my lord, they have been served. As per your last order, my lord, I also sent copies of this notice. They received it. It's a very peculiar affair, my lord. Kindly skip over to page 8, prayer A. First, my lord, I will state, my lord, I will not waste your lordship's time.
Page 8,
Paragraph A, that is prayer A.
paragraph.
Prayer A is related to hire purchase of a tractor.
Yes.
However, the petitioner moved the court below. However, the court below has passed order relying upon the order of the investigating officer. Now, my lord, investigating officer's report is at page 39. Page 39.
Yes.
And they have denied the finance company as well as the agent of the tractor, my lord. They have denied that they have taken over the tractor from the petitioner. This is the position. That the finance company did not take over the tractor from the petitioner. But fact is otherwise. That's why, my lord, I have made prayer in prayer A at page 8. Because anything happens, my lord, in regard to the tractor, my lord, the responsibilities will go to the petitioner. That's the difficulty. ওটা দেওয়া আছে আমার। Let the tractor and the trolley, my lord, be seized and let it be kept by the police itself till a decision is arrived at.
Where is the denial?
Page 39 and 40.
39, I do not find any denial.
Paragraph at page 40. Paragraph starts with, on my notice under section 41A CRPC, the said finance company sent a letter to me along with the same some documents relating to hire of purchase in between Mohammed Amin as the petitioner, borrower and the company. In the letter, the said finance company denied and reiterated the allegation of possession of the tractor from the borrower and owner Mohammed Amin. Clearly, my lord, they have denied. Has my lord got it, my lord? Thereafter, it also added that the company had never engaged anyone to repossess it. This is the stand of the financing company. But the fact is otherwise, my lord, the tractor has been taken away. It is running. Paragraph 9 of the application, my lord, the apprehension of the petitioner has been noted at page 5. Page 5, paragraph 9. Page 5, paragraph 9.
This is a matter of investigation. Since they deny taking your tractor and you say that they have taken it,
Yes.
the writ court cannot do anything about it.
Well, for that, my lord, I moved the learned court below. That was the order. That is the difficulty of the petition.
And the final report has been submitted in the.
Yes. That is the main difficulty of the petition.
Have you filed an RG of application on an objection to the final report?
No, not yet. I have no, my lord.
An RG application has to be filed against the final report, and the further investigation has to be directed. The writ court cannot help you because the report says that they have not taken it.
Well, then, my lord, may I suggest one thing? Let this writ application be disposed of with that liberty to the petitioner.
Writ application court cannot give you the liberty, which is the law.
No, yes.
A notice of the final report will be served on the petitioner. If the petitioner is aggrieved by it, doesn't support
That
it,
I know. That I know.
yes, he has to file an RG application. The writ court has nothing to do with this.
With this observation, let it be disposed of.
Yes, do you have anything to add?
Yes, my lord.
Do you have anything to add?
No.
Affidavit of service. None appears for the private respondents despite service. Paragraph. It is contended on behalf of the petitioner that the petitioner purchased a tractor bearing registration number WB61 capital A 2000 by a hire purchase agreement
From respondent number 6.
from the sixth respondent at a monthly installment of rupees 13,300 payable in 48 installments. Stop. Some of the installments were paid by the petitioner. Stop. Petitioner, despite which the sixth and seventh respondents snatched and seized the tractor from its driver in absence of the petitioner without preparing any document to that effect on 27 February 2016. Stop. The petitioner lodged a complaint before the learned Chief Metropolitan Magistrate, Kolkata, against the
Not the petitioner, but the sixth respondent. Financing company. Financing company. ওরাই তো করবে। That is at page 31.
The final report was in the complaint lodged by the sixth petitioner. You have not lodged any complaint before the
No,
authority.
that was before the Chief Metropolitan Magistrate. That was by the finance company.
Where have you lodged a complaint?
Where the petitioner lodged the complaint on
Dakshin Dinajpur.
ঠিক আছে। কোন জায়গায় বলো? কোন দিকে আছে? রিপোর্টটা কি দেবো? We have received a report. ওটা দিও না, এটা দাও, এটা দাগ দিয়ে আছে। লেটেস্ট রিপোর্টটা দিয়ে দাও।
Your complaint was before the district magistrate, Dakshin Dinajpur, isn't it?
They have initially moved to an application under 156(3) before the Chief Judicial Magistrate, Dakshin Dinajpur. After on the basis
Which
of
was
that,
registered as a
what
PR
PSK
case,
has started.
yes.
That is at page 28.
It's there. The petitioner
ওটা দিয়েছি
lodged,
আমি দিয়েছি। না না, ওটা আপনার আগেকার রিটেল রিটেস্ট। ওটা বোধহয় 22
this is a 156(3) application.
Yes.
Page 28.
Page 28, yes. 156(3).
The petitioner filed an application on the petitioner filed an application under section 156 clause within bracket 3 of the Code of Criminal Procedure before the court of the learned Chief Judicial Magistrate, Dakshin Dinajpur at Balurghat, on the basis of which a case being GR 1250 of 19 was registered. Upon completion of investigation, final report was submitted in the case with an observation that the finance company by a letter sent to the investigating officer accompanied by some documents relating to the hire purchase, comma, denied taking possession of the tractor from the borrower So, paragraph in the writ petition, comma, the petitioner has prayed for a writ in the nature of mandamus, commanding respondent numbers 2 to 5 to seize the tractor and hand it over to him. Stop. Paragraph. The complaint filed by the respondent relating to illegal seizure of the tractor by the private respondents has been dealt with by the court of the learned Chief Judicial Magistrate Balurghat.
রিপোর্ট একটু ভালো করে পড়ে নেবো, এত তাড়াহুড়ো করে হয়।
And prayer for further investigation made by the petitioner before the said learned court has been refused. The said order has not been revised against. You have not prayed for a criminal revision against the said order. That has to be done. This is not the forum. The petitioner, do you want to take steps? I'll record them.
Yes.
The petitioner seeks to take appropriate steps against the said order. Stop. Paragraph. Since the subject matter of the writ petition has been decided on merits by the learned Chief Judicial Magistrate Dakshin Dinajpur at Balurghat, Dakshin Dinajpur at Balurghat, and the petitioner seeks to approach the appropriate forum against the said order, nothing remains to be adjudicated in the present writ petition, and the same is accordingly disposed of. Urgent certified, etc. A full-fledged trial has been conducted, so the writ court cannot intervene. Service direction.
Obliged jewelers.
Page 59.
Better Mr. Zebra is appearing. He is engaged in court room number 42. Kindly let the matter fixed on Tuesday or Wednesday. And he is already on legs.
It's a very simple matter.
Ma'am.
Opportunity of hearing was not granted.
Two things, the person who decided, unilaterally decided, but not the board. And the provisions is that it has to be decided by the State Transport Authority Board. It has not been decided by the board, and the no opportunity of being heard has been given to the petition. This is the only thing. It has to be remanded back to the authority for it. Nothing is this. See, nothing.
I've given his name. He's
Shall I pass an order or give a short?
yes, you can pass an order. He's engaged in the code room number 42.
Well, Mr. Devra is appearing. I have no objection even if let his name be recorded also. But this is nothing. Again, I think I have to come again with the second hurdle.
Where is your, where is the impugned
Malat,
order?
page is Malat 27. The impugned order. Yes,
Reconsider. Reconsider. Yes.
And Malat, I pleaded in paragraph 11 that it has not been met.
কোনটা থেকে এটা উল্টা আছে এটা রিকনসিডার করবে তাই তো
Where is the permit?
My lord,
Where is the permit?
Malat, Malat, page 16.
2025.
But this permit is valid till 2025.
Well, this is the instruction.
It was granted by the deputy secretary.
My lord.
Permit was granted by the deputy secretary.
But only this, he is the signing authority. It has been granted, Malat, it has been granted by the State Transport Authority of West Bengal. Well, the issuing authority, Malat, the signatory is the deputy secretary. But the rejection.
I've seen the rejection, page 27.
Malat.
No, the instructions are submitted.
এখানে ইনস্ট্রাকশনটা কি আছে?
বইটা বার কর। তো 80 has to be followed in that even this has to be taken. Malat,
Shall I take this on record, Mr. Basu?
Yes.
Shall I take this on record?
I have taken a copy also.
I have already stopped.
Neither here nor there, doesn't mean anything. And I'm not on merits. Let the petitioner be heard.
Yes, Malat,
and let the
that
bench
your
decide.
lordship kindly appreciate one thing. Malat, the paragraph 3 of this Malat instruction, your lordship will find that section 80 subsection 3. Nevertheless, section 80 subsection in respect of the curtailment, variation, extension, inclusion, everything. But the
That will be hard.
procedure has to be followed. That is the, when if you are rejecting my application, then you have to give an opportunity of being heard.
Yes,
That is section 80 subsection 2 also says. So
That
like
I've
that.
stated.
Yes, I told me.
Instructions submitted on behalf of the respondents is taken on record. Instruction. Paragraph. The petitioner is aggrieved by the order passed by the RTO and Assistant Director, State Transport Authority, West Bengal, on 17th December 2022, turning down his prayer for curtailment of route route Monsukha to Howrah between Monsukha and Baroda Chaukan, CHOUKAN, on two full rounds, : the application has been decided by the RTO and Assistant Director and not by the board, and no opportunity of hearing was granted to the petitioner before his prayer was refused. Stop. relying on the instructions submitted on behalf of the respondents, submitted by the Secretary, State Transport Authority, West Bengal, Learned Counsel for the respondents submits that in terms of section 80 within bracket 3 of the Motor Vehicles Act 1988, an application for curtailment of route shall be treated as an application for grant of a new permit, and the prayer of the petitioner was dismissed since allowing the prayer would compromise the convenience of the common people. Paragraph. It appears that the order impugned was passed by the RTO and Assistant Director in his individual capacity and not.
My lord, not,
He's also a member of the board.
no, my lord, he is not a member of.
Assistant Director is not a member of the board.
No,
And not.
there is no post at all.
And not by the RTA board.
But STA board. It is by the STA.
Not by the STA board. Also, the petitioner was deprived of an opportunity of hearing before his application was rejected. Paragraph. In view of the above, this court is inclined to hold that the order impugned be that the concerned authority be directed to revisit the issue upon placing the same before the STA board and granting an opportunity of hearing to the petitioner. Paragraph. The writ petition is accordingly disposed of, directing the
Respondent number 2. Had the respondent of State Transport Authority. Regional Transport Officer to no, respondent 2.
Directing the second respondent. Accordingly, accordingly, the order / letter impugned dated order / letter impugned dated 17th December 2022 is set aside / quashed. Paragraph. The writ petition is disposed of, directing the second respondent to revisit the issue and take a resolution in the board meeting upon granting an opportunity of hearing to the petitioner, in accordance with law. Take a resolution in the board meeting in this regard. Upon granting an opportunity of hearing to the petitioner, in accordance with law. Paragraph. The entire exercise is expected to be completed within 6 weeks.
Yes. Within
6 weeks from the date of communication of this order. Disposed of. Exactly. Disposed. 60.
I am for the petition, my lord.
Respondents.
My lord, on your lordship, please to.
Today, group 7 is handicapped. Mr.
No, it's a blacklisting of a vehicle, my lord. Your lordship, it's a matter of life and livelihood. Blacklisting of a vehicle without hearing. My lord, Supreme Court number of times declared the law without hearing, without securing compliance of the natural justice.
A report was called for.
My lord, report not yet been already ready, but not affirmed.
This is
Only 1 week time may be given. I affirm.
in June, money your lordship.
One- one week time.
No. It is not a matter of.
That is ready.
From June, I have been suffering, my lord. Where from I shall get my livelihood, my lord? He says 1 week. 3 months I have already been lost, my lord. 3 months.
Mr. Shamat, wait for another week. Let the report be there. I'll hear it in the next week.
1 week time
Paragraph
to
Learned
affirm the
Counsel for the Learned Counsel for the respondents seeks extension of time to submit the report in the form of affidavit as sought. Paragraph, let the matter appear under the same heading on 12th September.
Would your lordship kindly this indulgence, my lord? Let them serve advance copy so that if
Please
I
serve an advance copy. Mr. Basu, advance copy.
Yes. Affirm. Sir, within 2-3 days, I affirm this. Already ready.
And serve an advance
Yes,
copy,
yes.
Mr. Shamat.
Page 61, my lord, I am
Well, in
praying,
this matter, I am planning on behalf of the petitioner.
I'm praying for not to on behalf of Mr. Ombudsman.
Mr. Sen is appearing on behalf of the state.
Today, group 7 handicapped. Mr. Sen is not there.
Well, kindly sort it next week, my lord, because matter is pending since 1 month, in the month of May, at the motion stage.
On prayer of the state, you are for the private respondent?
I'm for the time.
On prayer of the state respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading. On 13th September.
No.
13th.
Any days.
Correct.
Page 62,
State,
It's a long pending, your lordship kindly see.
state not there, private respondents not there.
I have served, they received it one long back,
Mr.
but your
Ganguly
lordship.
for the, you're appearing, he's appearing for, he's with you.
My lord,
Mr. Ganguly is appearing for the state. Where is he?
your lordship kindly appreciate. This matter is pending since, my lord. Since your lordship's order first passed way back in, my lord, June. So this is from June, your lordship was taking up this matter. Now, the issue I am kindly appreciate one thing. My lord, 3 times this petitioners comes with, 4 times this petitioners comes before the court.
No, for the
Only-
service is not required.
Only a vacancy. Well, the persons who is getting since past time, one after another writ petition filed challenging the grant, and the grant has been exercised against him. That person I have added. Since the first time he is getting wallet, he is one of the blue-eyed person of the state, maybe. One after another order was passed. Your lordship will find that the order from Justice Amrita Sinha, then Justice Mousumi Bhattacharya, then Justice, your lordship kindly count. Each and every time.
What is the impugned decision of 12th?
Your lordship kindly see the impugned decision is that page. Which page? Page 60. Page 62, right?
No,
Page 62.
12th October 2022. Oh, this is the memo, page 62.
But the word decision taken, well, this communication made. Decision. এর আগে decision of service purpose.
Means what is the wrong with, what is wrong?
I
with
will
the
also
order?
kindly come to the same. My lord, kindly come to page 39. The earlier decision. 38, my lord, page 38. কোথায় 38 টা?
38.
Page 38. Annexes P7. Your lordship will find,
Yes.
my lord, this is the decision adopted by the Regional Transport Authority, Howrah. Now, my lord, there your lordship will find the name. My lord, serial number 7.
Yes.
The person, my lord, Abdul Rahab Ansari. Now, your lordship will find the same name in this. It was challenged on the ground. There are two-fold ground. One is the jurisdiction. The Regional Transport Howrah having no jurisdiction after a notification issued by the government in 2016. There the Howrah Police Commissionerate, Barakpur Police Commissionerate, Kolkata Police Commissionerate, and the Bidhannagar Police Commissioners. These areas has given the power to grant permit, renew the permit, and every Regional Transport Authority's power, which has been taken to and vested to the Regional Transport Authority, Kolkata region. Remember, this route, the route where my clients applied for in before the Howrah, that the route is covered by the Howrah Police Commissionerate. Number it cannot be, it is not the right of the authority to consider the applications. Number one fold ground was there. Another is that the one a cut-off date decided by the authority, by which one has to produce the documents by which he can show his financial stability. Number the date, cut-off date, it is a notional one. That has been set aside because there cannot be a cut-off date showing the bank balance on that very particular date that you have obtained the highest balance in your account.
The determination part is over, I think, because this has been.
Jurisdictions part is over, and the other part, that is the.
This is by the RTA Kolkata. So that.
Now it is by RTA Kolkata, that part over. Now the person who has got.
Ground of challenge to this, the present.
Your lordship, the grounds of three-fold, four-fold grounds are there. But one is these persons who. This is a route under section 74(3)(a) by notification.
In compliance with the earlier order of this court, coordinate bench.
This is in compliance with the of this court.
What was the direction in the order?
But there the direction, lordship will find the next page, that is at page, the order is at page 38. The judgment delivered by the coordinate bench, that is at page 38.
The relevant portion?
The relevant portion is at page. Right. This starts from. Which page? Sorry, bear for a moment. That is not the page. Page 39. The decisions, your lordship will find that page. The judgments page. There are some observations up to page para 21. And then the decision, the directions is on the light of the page 45, paragraph 22. In the light of the above observation, so and so is allowed, thereby setting aside the order of so and so, and whereby the RTA selected one so and so sole vacancy for the grant of auto rickshaw.
A cutoff date was stated as March 11, 2022 for the bank balance.
For the bank balance. within.
So after this, a hearing was granted to you?
None. The 8 applicants were there for
There
one
are two
vacancy.
issues in the, as I find from the earlier judgment. One was the jurisdiction.
Jurisdiction point.
Which is no longer there. It was decided by the RTA Kolkata. And second is the cutoff date.
Fine.
The court held that the authority ought not to have decided that cutoff date.
Judgment for justice.
So what is the what is
No, well-
wrong with the application?
I'm submitting. This is a route mallet under section 74(3)(a). But this is a notified route. Under section 74(3).
Because it will be better if the state comes. I'll just record that it will be taken up even in absence of the state on the next day.
That. But as because your lordships has already passed an order, your lordship has already passed an order, though there is no interim order, but your lordship has
Yes.
partly that is an interim because your lordship has to abide by the result. That I have
Because it is only for the state to respond.
mine.
So if it is disposed of today, it will be a
No,
ground for
man,
appeal.
that will not actually suffice
be a purpose.
because it needs your lordship's intervention, whether the grounds which has been I have taken, that is justified because let them.
None appears for the respondents. Stop, no accommodation is sought. Paragraph, let the matter appear under the same heading on 15th September. Paragraph, it is made clear that the matter shall be taken up for consideration on the adjourned date, even in absence of the respondents.
In any event, your lordship, the name of the erstwhile advocate on record, who is appearing for the state, I think he is
Mr. Ganguly is appearing.
Mr. Ganguly,
I saw him just now.
may I?
Kaushik Ganguly and Mr. Subroto Dasgupta. Their names are
Osim
recorded.
Ganguly, I think he is in the panel, but so far as his junior is concerned, I have heard that he is not.
Now he has a code number 14.
Who?
Osim Ganguly.
No. May I?
Please inform him once.
Verbal information or I have to write?
Verbal information. I'm not recording anything because today he has not appeared.
Page 63.
Now Mr. Mondal is fit quite as far as his legs is concerned.
Well, this is my application, my lord.
May I submit report, my lord?
My lord, probably lordship has directed the legal metrology and the railways both to file a report. So far as the legal metrology is concerned, my lord, they have served a copy upon me. And so far as the railways is concerned, my lord, today the report is being served.
Sorry, my lord.
It has been affirmed.
Mr. Mondal is not fit. That is why, my lord.
No, that cannot be the ground, my lord. Railways is a
True, my
separate entity.
This cannot be a ground for your report.
No.
But the 9th
It has
of
already
June, it has been affirmed. 9th day of June, my lord, today, my lord, my learned friend in September is handing over a copy and that to the day of hearing. He could have at least served me an advance copy.
Because it has already filed Mr. Mondal, my lord. But as far as Mr.
Because this
Rai is concerned, that is.
Well, I am the party who have to respond because I have nothing against the legal metrology.
Want to come up with an exception to this report?
Definitely, my lord, I have to come up with because in view of the fact that several rules have been highlighted by the legal metrology, which is in supporting my condition, my plea. My plea is for refund of the punitive charges because the machine which was there at that material point of time, lordship, overloading was detected. I approached before this honorable court. This honorable court, lordship, directed them to do a rearrangement of the empty track, empty wagon, my lord.
That was done, and also in that report I have annexed, my lords, several readings have been obtained over a single lordship payment. Sometimes 30 tons, sometimes 32 tons, sometimes 33 tons. Now they say, the legal methodology is saying that maximum permissible error is 4.6 tons above the normal weight. That is, lordship, 23 ton is the carrying capacity.
Does that cover this case?
Normal, I say that the
That is
interesting
not
thing is,
sharp upon me, my lord. As per
what
state
is
reg-
legal metrology has
as per
stopped
state-
upon it.
state- No, that is not sharp.
Now, my lord,
You know, so kindly
23
give me
ton,
some time, my lord,
kindly,
what time I
lordship
can-
will be
I can
starting
keep
to
reply,
see,
my lord, as far as
excellent, just a minute. 23 ton is the carrying capacity. Now, railway says if we overload by 1 ton, it will be treated as an overloading. But legal metrology says that if the variation is anywhere within 20% of the total weight, that is 23 ton, 20% comes to 4.6 tons, then the machine is functioning okay. But railway will charge overloading for that. Now, if, my lord, for an instance, I load 20 ton within 23 tons, it's absolutely permissible. I don't load 3 tons more. But the weighbridge, it will, if it shows that it is 27 ton, then the railway will impose a slab of punitive charges against me. But the legal metrology will say it is within the permissible error. This is one aspect. Second aspect, the legal metrology has highlighted a very important and vital thing, my lord. In the report, they have said that any payment has to be undertaken within 1 km/h to 15 km/h. The train should have a speed limit within 10 or 15 km/h. If it is within that, then the appropriate, at least some of authenticated payment can come out. If it is beyond that, then there will be an error. Now, I don't know, my lord, whether my learned friend has covered all these aspects here or not. Because railway, under the policy, I have brought the manual with me, my lord. I have loaded 20.
Dealt with these aspects, Mr. Chakraborty?
Yes. I have some exception.
So kindly see, I have not seen.
Dealt with these aspects that are being stated by the petition?
Yes, yes. Yes, madam.
Yes.
I have to give in no, my lord. That is, it was previously, my lord. I have no copy as far as this legal metrology report is concerned, madam.
Mr. Mondal, please hand over a copy so that he can deal with the issues.
Yes, madam.
If my lord friend wants my,
If any sharp copy, my lord, I made a.
I have some the petition.
made
I am
exception.
relying upon the legal metrology because legal metrology has highlighted the exact.
Just now, my lord.
Dispute interest, so let them deal.
Yes,
with
madam.
Because it is a dispute in between them.
Yes.
it. Let them deal with it.
Yes.
Let them deal with it. And I have asked,
If you want to come back with an exception.
I will file an exception so where railways affidavit is concerned, my lord.
But as per my small knowledge, my lord, Central Act prevails, my lord. When State Act and Central Act, my lord, contradict, my lord. As per my minimum knowledge, my lord, Central Act prevails.
Please respond
Yes,
to the.
Probably, my lord, my learned friend is not aware of the fact that the legal metrology is the department who has been given the responsibility for upkeeping the machines.
There is no question of a central act or a state act in this.
But that is loading, my lord. As per loading restriction is concerned, my lord. Learned friend is said, my lord, 23 tons and 27
No,
tons.
metrology deal with the correctness of the machine.
Yes,
yes.
Only, my lord.
Yes.
So it shows,
my lord, overloading.
You have no case.
Yes.
Prima facie, it appears that there is a conflict in between the two
I
departments.
made my lord objection.
It's apparent from the report.
Exception in this matter.
The reports in the form of affidavit submitted on behalf of respondent number 5 and respondent numbers 2 to 4 are taken on record. Paragraph learned counsel for the learned counsel for the petitioner seeks to use an exception to the report submitted on behalf of respondent numbers 2 to 4. Paragraph, let the matter appear under the same heading on 20th September.
Not against an allegation. Huh?
20th September.
Yes, my lord. Let it be heard and disposed of on that day. But rules are there, my lord. Legal metrology has, being an independent umpire, my lord, I will say, use this word. They have brought down the rules which has to be followed. And if railway do not follow those rules, then lordship, I have a good case.
That I have to check it up. As far as
How
report
they
is
can
concerned.
check?
Report filed, I have no report, my lord. As
This
far
is
as
the
legal
report they have filed. They cannot ask
that is
anything.
true, my
about
lord.
this.
But legal metrology report just I got, na.
Next.
864.
আর কত আছে?
864.
Service
Service is there.
was not complete on the earlier date.
The matter appeared, my lord.
Yes,
I
but
think-
there's a direction for service on the earlier date.
That was. And they also appeared, my lord. Yeah.
Who appeared? No, I do not find any appearance.
So last occasions one. Huh? I think Miss Pandey appeared in.
No, her appearance is not noted, not recorded.
My lord, issue involved, your lordship has already delivered two judgments in same issue.
Bihar and West Bengal, both are involved.
I have no allegations against,
West Bengal.
because this is my lord, that issue where my lord, your lordship has already delivered in two matters in two judgments, there they prefer the appeal. Where my lord, I filed the contempt applications for not complying with the order. That is my lord, the distance covered according to the notifications. It is my choice to place either one vehicle or two vehicles. They are saying now this is mandatory that you have to place two vehicles.
It's May.
Very, yes, May. Yeah, and your lordship has already delivered two judgments and they have not complied with till date. The contempt has been filed. Every time they came and they said that the appeal has been
I
preferred.
cannot request anyone for the state. There is no one today actually. Anyone who appears. in
The
serving
last
matters for
occasion,
the state,
as because I have no allegations, SUVRA is appearing on behalf of the state that I have seen. State of West Bengal, but I have no allegations.
but
against
no
whether the-
appearance is recorded. That is the difficulty.
then
And Ms. Aishwarya has also not recorded her appearance. Let me fix a date. Will you serve and come back? Will you inform them and come back?
I have already served, my lord, the intimation
Intimation of the next date to both the state of West
my
Bengal
lord,
and
I
affidavit of service. None appears for the respondents. Paragraph, let the matter appear under the same heading on 22nd September. Paragraph, the petitioner is directed to serve notice upon the respondents intimating the adjourned date.
my lord.
Because no use passing an order in their absence.
My lord,
If you again
that
come
side, and my lord, I don't know, my lord, this has already been decided by my lord. Even if
But
they things to my lord, taste these my lord's judgment, they have a right to prefer the appeal. They already preferred two appeals. That is not been taken up. No stay has been granted. My lord, next date your lordship has decided. If they fail to come with the then my lord, because we are waiting for more than
But their
8 or 9 months. My
Next.
865. In this matter, I am appearing on behalf of the private respondent. Mr. Devra is appearing on behalf of the state. He is engaged on another court. But next,
Here, my lord, this, my lord, your lordship, that matter. Where, my lord, he is operating vehicle on a different route. I have raised objection. The state transport, the West Bengal also said you are operating in an interstate.
but on this hill.
There, my lord,
Before the honorable.
he has told before the honorable,
The matter was hard. But finally was hard. Matter was taken up.
nothing is there, my lord. My lord, I have already. No, my application,
Matter
my
will-
writ petition, please. My writ petition, you are.
I know you have the
He is operating a lordship, can you see? He is.
There is an observation in the earlier order that an appeal is pending before another high court. So let
No
there
appeal,
not
no.
be conflict in
The
decision.
read petition.
No, an
read
appeal is
peti-
pending. before the
No,
original.
no, read petition. Your lordship, can
What is I was clear. Malo matter was in the 4 occasions, matter was hard. Matter was, ultimately, matter was, hearing was completed. Matter was fixed for judgment. On matter was fixed on 27th September. So kindly matter is taken
Well,
up.
then your lordship kindly appreciate. He is, kindly appreciate. He is operating a vehicle. It's a notified route. Well, interstate route. This is an interstate route. He is operating a vehicle on a different alignment, and he is asking variation of this route, but that has not been granted. Even by the state transport of the West Bengal, they told that you go there. They have refused. They challenge. He challenge only. But that is pending, and on that basis, he is operating on the different route. This is interstate route.
Pending for judgment. That is pending for judgment.
I have placed this last order. There is no such order.
No, no, Mr. Khan says it is
Yes,
pending for judgment. No, no,
Where
Where is that order?
Last mal order,
Where-
can you see? Matter 2026 September, can you see?
No, but what,
Latest order.
what-
Matter was heard on
yes, yes,
28th.
what is the challenge? Your lordship kindly see what,
Challenge means, my lord, we have.
What is the challenge?
Street of Bhagwanpur, via Conta, that matter is pending. Therefore,
Another
matter was.
heading orders. Let
but
us wait till
the,
this.
your lordship kindly see what is the challenge? Challenge is that, my lord, the authority rejected on the ground that this is not within the, my lord, state, interstate reciprocal transporting. So it should be brought in the interstate reciprocal transporting. Before that, he cannot operate on a different route. That is the issue. Now he is saying it before that.
Operating.
But this has your lordship kindly see.
That operation is challenged in the present.
Not
present
motorway.
situation.
The accident was occurred on this ground.
Lordship kindly, one thing, your lordship kindly, mere making of an application. Can I operate a vehicle on a particular route without giving an?
Different route. Here, no operation.
The same issues are being
Unless it's
adjudicated by the other high court.
That has not been adjudicated. Malad, the court.
Yes.
The-
other-
No, Malad.
the Orissa
Malad, the
High Court-
honorable high court, Malad, Odisha, Malad, that has not been decided. So
That has not been decided. It is fixed.
So
on the
can
decision.
that be? I have a permit. That is one.
Come back
One
after
thing.
26
Can
September.
that be? I have a permit on a particular alignment.
Then
Now, can I-
On merits, I will not decide. Let the order be passed. 26
Then,
September
Malad, there
is the
should be
date.
an intent not to operate on a different.
No, no, the matter is pending. Yes.
Not to operate. Your lordship kindly see.
The entire matter is pending before
Yes,
the other
yes.
court. I cannot pass any order at the moment.
This is only part of the Bengal.
Paragraph.
Your lordship kindly
Did
see.
you
Bengal
confirm
decisions.
The observation made in the order passed on July 14, 2023. The matter was adjourned on the same ground on the earlier date. Paragraph, let the matter appear under the same heading. 26th is the date for 3rd October.
Let him allow to operate on a particular route where he has been given.
Let him come. Let
But
let-
thereafter, if he win there, he must get that.
let us see
Before
what is
that-
what is done, come back. Two high courts dealing with the same matter. is
This your
beyond
lordship
judicial-
kindly appreciate.
This is beyond judicial propriety.
See,
I cannot-
even no interim order against, before, on his hand.
There is an interim order passed by the other court.
No, where is the interim order?
The order says.
But a stay of that order, the rejection order, that not amounts to the, this is not, cannot be taken as an affirmative one.
I can understand your
Your
submission.
lordship
but then please, let us wait for the next. Next.
866.
I am for the.
Are you using an exception to the report? Not necessary?
Not necessary, because the complaint was, my lord, the number of auto rickshaws are plying on the different route where we are operating my vehicles. My lord, the under section 66 and 192, nobody can ply, my lord, without any valid permit.
What is your
My lord was
evidence?
pleased to direct the respondents to file a report.
They have filed. a
According
report.
to their report, they seized only 7 or 8 vehicles, my lord, 195 auto rickshaws are plying without any valid permit.
What is your prayer?
My lord, the prayer, my lord, to take steps, my lord, against those illegal and unauthorized plying of auto rickshaws. And that is the, my lord, your lordship kindly direct the, my lord, the motor vehicles, my lord, the department, Regional Transport Authority, Alipur, my lord, to file a report. My lord, the police has nothing to do. My lord, they have issued permit for plying those auto rickshaws on a particular route. But the auto rickshaws are not, my lord, following that route, my lord, they are plying on the different route. Your lordship, my lord, may I, my lord, at this stage, your lordship direct the motor vehicle inspector.
Motor vehicle inspector is not the implementing authority, sir. The police has to implement.
Police, And my lord, as well as
Inspector may or may not issue.
and
permit.
also my lord, regional
But we
transport.
cannot stand on the road and find out whether the autos are running with or without permits. The police authorities, that's the police's job, isn't it?
Police is my lord, under section 192A, motor vehicle inspector can my lord, my lord, you will also kindly see.
Supply the auto number. He has to supply the number.
Yes, I have complained, I have annexed the document.
Where is the
I
number?
have annexed, you will also kindly see. I have
Where is the
annexed those
number?
numbers. Page 38. Page 38 onwards, they have my lord, these auto rickshaws are plying, 145 auto rickshaws are plying on the different route. And also, your lordship also direct the concerned police officer, officer in charge of the Bishnupur police station, to take immediate steps. Those applying without any valid permit. On the basis of my complaint at the annexure,
Page.
Page
39.
Page 49. Yes. 39, 45, your lordship, my lord, the lawyer notice that can be, my lord, the
Lawyer's notice will not.
three complaint, page 42, 43. 43. And I have given chart, my lord, how many, my lord, the auto rickshaws are plying. That is annexure, my lord, the page.
Page.
Page 38. Their permits 37, different route, but these auto rickshaws are plying on the different route. We made a complaint. We are operating on the basis of the valid permit on the particular route. They are operating, my lord, their vehicles on my particular route. Page
You
30.
have listed 145 auto rickshaws.
Yes, yes.
You say that they are running without permit.
They are without permit.
All these 145 auto rickshaws are
Yes.
without permit. Mr. Debra, list has been provided. Page 38.
And page 43, this is the complaint. Three complaint, page 41, 42, 43.
Yes.
Transport department কি?
সব জায়গায় দিয়েছি আমি ট্রান্সপোর্ট ডিপার্টমেন্টেও দিয়েছি এই যে পেজ 41 দেখুন রিজিওনাল ট্রান্সপোর্ট অথরিটি আলিপুর ওটাতে ট্রান্সপোর্ট পারমিট দিয়েছি কিন্তু পারমিট তো অন্য জায়গায় চালাচ্ছে না নেক্সট পেজ দেখুন এটা নেক্সট পেজ 38
দেখলাম লিস্ট নাম্বার পুলিশকে দিয়েছিস
লিস্টও দিয়েছি পেজ 41 বিষ্ণুপুর পুলিশ স্টেশন মেন ম্যাক্সিমাম কভার করছে বিষ্ণুপুর পুলিশ স্টেশন
Only 6 autos have been detected out of 145.
Unfortunate. Lordship, kindly to direct the police authority to take immediate steps and seize the victim. Otherwise, my lord, here motor vehicles inspector, there are 2 or 3 motor vehicles inspector in a region. How can it possible? Without assistance of the police authority? Spot number কত?
Let page 42 be considered by the motor vehicles authority
My
and the police be directed to assist them.
My lord, that is the
Yes.
one.
to take steps. My lord, the
Police is
to take
directed
steps,
to
my lord,
assist.
against the illegal or unauthorized flying of authorities. This is the, my lord, the if they have valid permit, they
Valid permit, there is no question of seizure. Without permit, my lordship can direct the seizure, seize the vehicle.
Direct the
Seize.
to seize the vehicles. If they do not have
There is no papers.
if they do not have any permit,
court will direct taking immediate steps.
Yeah, steps, please.
The petitioners complain that several auto rickshaws are plying on the route Thakurpukur to Bagrahat.
Thakurpukur to Bagrahat. No, my lord,
Without having valid permits.
no, my lord, the page 37, Joka Khalpul to Bagrahat. Thakurpukur to Bagrahat, we are operating. Yes, my lord's right. Thakurpukur to Bagrahat. They are operating Thakurpukur to Bagrahat, right.
Without having any valid permit, or in violation of the permits issued in their favor. The petitioners submitted a representation in this regard before the concerned authority on 22nd January 2020, and also provided a list of the said vehicles. This list was given to the authority.
Yes.
Provided a list of 145 vehicles. 145 vehicles which are plying illegally / unauthorizedly. Stop. Paragraph, learned counsel for the petitioners submits that no step has been taken by the authority in this regard. Paragraph, relying on the report in the form of affidavit submitted on behalf of respondent numbers 3, 4, and 5, learned counsel for the respondents submits that the authorities are exercising due vigilance to curb illegal flying of auto rickshaws. Paragraph. Upon consideration of the submission made on behalf of the parties, this court is inclined to hold that since the representation submitted by the petitioners on 22nd January 2020 is pending before the authority, and a list of alleged illegal a list of 145 auto rickshaws allegedly flying illegally has been provided to the authority by the petitioners, the authorities be directed to take necessary steps in this regard at the earliest in order to curb illegal / unauthorized flying of auto rickshaws, endangering human lives. Paragraph, the writ petition is accordingly disposed of, directing the who should consider your representation.
Respondent number. Now, RTA with the. The lawsuits were 6 and 7. Because the 7 is the authority issuing permit and 6 were the concerned police officer. 6 and 7.
Let 7 be directed
7 be directed.
and 6 be directed to assist implementation.
Yes.
Directing the 7th respondent to deal with the representation of the petitioner and take necessary steps in this regard.
I will 6 my lord, assist.
In an expeditious manner. Paragraph. The 5th and 6th respondents are directed to render all possible assistance to the 7th respondent in complying with the order of this court.
Well, the only matter and the online matter, the petitioners are giving liberty to supply the chart of the 145 auto rickshaw.
You have not supplied?
Yes, I have supplied.
Then-
Again, my lord, the losses, my lord, the how many are.
Since
So
I've
that-
recorded that you have supplied, give
Yes,
fresh copy, I'm not recording it.
$867.
Shall for the writ petitioner in this matter. Worship, this matter is, she will remember, this is a second round of writ petition. Second round of writ petition.
It's appearing.
Yes, Mr. Nayak along with Mr. Ribu Datto is appearing in this matter.
Where
My
are
lord,
they?
my lord, I have served, they have appeared in this matter, my lord. I took adjournments, lordship, on previous occasions. I should be candid before, lordship. Now, lordship, this is a matter, lordship will remember, which pertains to 5 minutes and 10 minutes of stoppage time. Initially, lordship, petitioner got was favored with a contract, my lord, as he participated in a e-tender. The contract was executed. It was under an old policy.
In a subsequent.
Subsequently, an e-tender was issued. It says that in addition to that, the intermediate stations where facility exists of 5 minutes of stoppage time, that will be provided to the leaseholders. Now, I came before this honorable court with the plea that another leaseholder under a new policy who has been awarded with a contract,
You want an indiscriminate treatment.
a discriminatory approach. Now, my lord, they have issued a speaking order. The speaking order has negated my contention. Now, my lord, in filing this writ application, my lord, I have come across a circular of the railways.
Why don't you come back upon service of notice to them?
Service on my have.
It's a notice.
Yeah.
Intimate them the adjourned date.
Yes.
That's
Yes.
all. Otherwise, it will not.
Lord, she fixes any day. Lord, she fixes any day because it requires hearing, my lord. I'm not seeking any interim order.
Their absence will really.
No.
defeat the purpose. None of these for the response.
We taken up today. Our kindly addition.
They have got no locus standi, my lord. They are plying on a different route, my lord.
Without approval of time table, he has been flying vehicle.
Without the timetable.
My lord, I have been given permission to ply, my lord. I will produce that permission, my lord.
Vehicle.
RTO has given me permission, my lord.
RTA might have issue, secretary RTA, might have some connection with you. Otherwise, how can you apply? How can you apply? And apply for your also kindly allow the application petitioner party. Let him.
Let him come back.
My lord, only not today.
Please be ready on the next.
My lord, without fail, my lord, without fail. Without fail, my lord.
Kindly fix the next.
One of you took time.
Yes, my lord, not me, my lord.
Your lordship kindly see.
He is not consistently taking time. Come back on the next occasion.
My lord, on which day? On the
I will, my lord.
which day I have no brief.
But absolutely, my lord.
No, no, my lord. Next day, if I fail, my lord, your lordship passes the order.
My lord, 17th of May. My lord, your lordship kindly notice your lordship order. 17th of May, 23rd of June. My lord, your lordship kindly see. Your lordship.
The addition of
17th
application, additional party,
was,
exchange.
petitioners did not take time.
Well, thereafter, my lord,
You have missed 23rd June when one of the applicants took time, one of you.
my lord, we filed application 17th of May. For that reason, my lord, we brought to your lordship notice we have applied for.
Time was taken by one of
Well,
you.
may I submit one thing?
My lord, if-
On prayer of the petitioner.
Mana application, mana affidavit has already exchanged.
Let the matter,
Short case, kindly short date, kind of next week,
let
any
the
day.
matter appear under the same heading on 19th September.
Grateful, my lord.
Please
But-
be ready on the next.
Yes, my
occasion.
lord. Without fail, my lord.
September. Eight 69.
I'm for the state respondent, your lordship.
Petitioner,
Well, I'm paying on them.
you're for the petitioner.
Yes.
Only one thing, my lord, in this matter, I have been added as a party respondent. I missed the brief. Kindly allow me one day at them.
Your prayer was allowed. Your prayer was allowed on the.
Yes, yes,
earlier
my lord, I have already been added as a party.
But that application was allowed.
Short date, any-
But next week, any day, my lord, because matter is pending since in the month from May. My lord, at least 4 occasions, my lord, matter was hard adjourned. Kindly 13th. Next week.
There are matters pending since 1967, sir. You are saying May 23.
No, my matter was filed on.
in 19.
This is a 2023 matter.
Yes.
There are matters which are pending since
Yes, madam.
1967, 1970. He says May, that's why I said. On prayer of the, you're the added respondent, no?
Yes, my lord, I am right.
Well, affidavit was there for 17th May. So my matter was last after
Which year? May which year? Before how many years?
23. But at the motion stage.
Yes.
But I am affected for this regime. I have challenged the resolution.
Are you
I have
aware
challenged the
as to
resolution.
motions?
And that is, my lord,
Are you aware as to motions from which year are pending?
I know that. But, my lord, because my client is suffering. So for this reason, my lord, because I have challenged the illegal, because on the false
On
allegation.
prayer of the added respondent, the matter is adjourned.
Yes, no, no.
Let the matter appear under the,
Or short date, my lord, because it's under Article 226.
September.
Yes, review.
Paragraph, the department is directed to incorporate necessary correction in the cost title of the writ petition in terms of the order passed on July 14, 2023. The name has not been recorded. Necessary incorporation.
Cost is amend করে দেবেন।
The department is directed to cause necessary amendment of the
Amendment has to be carried out by the applicant record.
My junior has not come today.
The department.
Yes, ma'am. Department.
I'm sending it down to the department. অর্ডারটা টাইপ করে দিবি তো তারপরে 870
Lord, I appear for the petitioner, my lord. On the last occasion, my lord, I was directed to, my lord, add, my lord, meteorological department and to serve a copy, my lord, upon them. We have served a copy upon them, my lord. And so far as, my lord, the railways is concerned, my lord, they were directed to file a report, my lord. We have received a report, my lord. We shall file an exception. Yes, submit it.
who is appearing for the metrology?
For the railway, my lord. My lord, we have served the meteorological department.
So they try to appear.
Yes, my lord, he is also appearing in a similar matter.
It's an exception.
Yes, my lord, I shall give it to.
You want to come back with an exception?
Yes, my lord, I shall come back with an exception, my lord, and in the meantime, if my lord, the meteorological department also files their report.
You want to file a report, Mr. Debra? He's not aware of what is there inside.
This matter, my lord, we have said, my lord, that this way was not functioning properly. After that, there was an inspection carried out, and it was found that it is not in range. We say, my lord, that it was not in range prior to the date of it was actually certified. So therefore, my lord, the direction was given to add them and to, my lord, file them an affidavit indicating whether, my lord, the way bridge can only be, my lord, out of range on that day, or shall, my lord, be out of range from the date previous on the.
When the, my lord, the
I think that
consignment
report
was
will be
waited,
necessary then.
Yes.
when the consignment was waited, my lord, at that time, that was functioning properly.
That is
It
the
is not
question.
that is the single consignment or that the various consignment was waited at that time. And when 7 accept this matter, my lord, no one was raised any objection. And after taking the delivery, they have raised the objection.
No, my lord,
So, my lord, how it is possible for you, Edmund?
let
They
them
have
come up with the
paid the
report.
charges. They have taken the delivery.
They are asking for refund of the money.
Yes, my lord, on the ground that on my allegation only this inspection was carried out, and it was found that it, my lord,
So
out of.
Inspection was held periodically.
the
And the legal meteorological department, they have also, I have also annexed the certificate that at that time, my lord, that is functioning properly.
So let them come back with a report. Affidavit of service. তার আগে করুন, report in the form of affidavit submitted on behalf of respondent numbers 1 to 6 is taken on record. Upper affidavit of service filed by the petitioner is taken on record. Petitioner is taken on record. None appears for the 7th respondent despite service.
My lord,
Mr. Debra, who is, yes, I should record none appears first.
Right.
Mr. Debra, who is present in court, regularized forum, copy service connection. Paragraph, learned counsel, along with the junior of his choice. Learned counsel for the petitioners seeks to use an exception to the report in the form of affidavit. Paragraph, learned counsel for the 7th respondent shall submit a report in the form of affidavit in this regard. Paragraph, let the matter appear under the same heading on 27 September.
great.
Should be sufficient. 28th is a Thursday, original side date.
27th, I have some.
Well, 29th.
Great.
29th.
Our report may be kept.
It's taken out.
এখানেই করে অ্যামেন্ডমেন্টের জন্য তো যায় না। 871
मतलब रैम पर petition number.
Amendment টা কি ওনারা party করবে? তাহলে ওই লাইনটা কেটে দিন।
हाँ?
तो आगे
তাহলে এখানে করতে হবে না।
फैन को प्रेस चाहिए पूरा कंसिडर
Departmental লাইনটা কেটে দিন।
হ্যাঁ আমি সান্ডা করে দিচ্ছি আমি চালাই मतलब पर्सन टू लॉर्डशिप लीव माय लॉर्ड आई फाइल द सप्लीमेंट्री एफिडेविट मतलब इनिशियली आई हैड अप्लाइड फॉर grant of permit in a route yes sir initially I had been granted a permanent such gas permit that was not economically viable. I have surrendered the permit thereafter my lord because I purchased a new vehicle BS6 high range of installed my lord. I made a further application in a different route for permanent such gas. I pay that application permit considered within a particular time. मतलब your lordship kindly see annexure P13 paying P1 that was
So that was surrendered.
yes my lord
You stated that the supplementary.
yes my lord you have annexed that my lord huh supplementary that's
1 year, one after another change.
no क्या কি করে না চললে কি না চললে কি হয়েছে ম্যাটার my lord page 13 my lord of the writ petition P1 this was received on 26th of April 2023
Within 2 weeks.
Within 2 weeks, my lord, RTA board has to be.
করে দাও না একটা করো না ইনস্টল গাইডে চলে যাবে না
2 সপ্তাহে হবে না RTA।
চেষ্টা করুন তো
এক বছরের মধ্যে
Supplementary affidavit submitted on behalf of the petitioner is taken on record.
मी actually झालं बोलतो because of you. तुम्ही ज्या बोलत आहे ना ना आजचे बोट करू आवाज
The petitioner seeks issuance of permit in his favor. In her favor for the route Rajnagar to Budham bus stand.
Rajnagar to my lord, this is Rajnagar to Bardhaman, Novabhat bus stand.
Rajnagar to Bardhaman bus stand.
Bardhaman, my lord.
Bardhaman bus stand.
Bardhaman bus stand at Novabhat, my lord, that is.
Bus stand at Novabhat. Huh? Novabhat. NABHAT, Novabhat. It appears that earlier a permit was issued in favor of the petitioner on the interregional route Rajnagar to Panagarh Bazar, the earlier route Rajnagar to Panagarh Bazar. The said route was not economically viable, the petitioner surrendered the said permit by a letter issued on 30th January 2023. Stop. The application filed by the petitioner for issuance of permanent stage carriage permit along with prescribed fees on
26th of April.
when did you file?
In the first page of the application, endorsement is there.
26th May, 26th April.
26th of April.
On 26th April 2023 is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the same. Paragraph is submitted on behalf of the respondents that the
Respondent number 2.
the second respondent be directed to consider the application in accordance with law. Paragraph in view of the above, the petition is disposed of, directing the second respondent to consider and dispose of the application filed by the petitioner dated such and such within 4 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to the
Yes. Second respondent.
petitioner, in accordance with law.
My lord.
The decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of. Hearing matters. আজকে আছে
ইতিমধ্যে বলা হয়ে গেছে 32 কথা বলার টান আসেনি
Group 1 hearing, fixed at 3:30, item 1051. 1051.
Well, I pay for the KMDA. Well, on the last occasion where I have concluded my submissions, but well, in a hurry, Millard, I forgot to cite two decisions. Kindly permit me 5 minutes. Millard.
Churi. Uncle Churi.
Yes. Petitioner, Mr. Pan was there. Oh, he's taken a seat.
But if your lordship record,
Mr. Basu was there, is he?
yes, Mr. Basis Junior.
Sir, appeared.
He's not there. But I'll give him.
জলপাইগুড়ি গেছে না?
Actually, I am led by Mr. Mukherjee. Today he has problem, but I mean requested to continue with them.
But if your lordship recollects me, on the last occasion, I made submissions that he is a post-vesting transferee. He has got no right, number one. Number two is that the transaction or the sale transaction itself is void. And consequently, my lord, the delay and etc. My lord, I have made my submissions. But only to add to that, my lord, kindly have a look to my lord, two judgments. The first one is Shiv Kumar's case, which is 2019 volume 10 Supreme Court cases, page 229.
SCC?
229. Because this case takes us even backwards. Because Mr. Mukherjee had made his submissions elaborate that after 4(1)(a), if no award is passed within a particular period of time, then the notice gets void, lapse, etc. But here, kindly similar what the Supreme Court says at paragraph 8.
Paragraph?
8.
Yes.
It has been laid down that the purchasers on any ground whatsoever cannot question proceedings for taking possession. A purchaser under section 4, a purchaser after section 4 notification does not acquire any right in the land as the sale is ab initio void and has no right to claim land under the policy. Therefore, my lord, for section 4 stage onwards, this is Act 1, this judgment. My lord, if there is any transaction where it is void. Then, my lord, the court at paragraph 9 says, when we ponder as to the beneficial provisions of section 2 of 2013 Act, they also intend to benefit landowners mentioned in the notification under section 4, not for the benefit of such purchasers who purchase the land after it has vested in the state. So again, section 4, my lord, the Supreme Court says that these are not meant for subsequent purchaser. Please take the next paragraph. Subsection 4 of section 11 of the 2013 Act, which is akin to section 4 of the 1894 Act, contains a prohibition that no person shall make any transaction or cause any transaction of land or create any encumbrance on the land from the date of the publication of such notification. That is notification under section 4. Then please take me paragraphs 18, 19, and 20. Short paragraphs, Miller.
Yes.
18, 18, 19, 20. Even otherwise, proviso to section 24(2) does not recognize a purchaser after section 4 notification inasmuch as it provides that where an award has been made and the compensation in respect of majority of the land holdings has not been deposited in the account of the beneficiaries, then all beneficiaries specified in the notice for acquisition issued under 1894 Act shall be entitled to compensation under the 2013 Act. The proviso makes it clear that in case of compensation concerning the majority of the land holdings has not been deposited, then the recorded owners at the time of issuance of the notification under section 4 of the 1894 Act shall have the right to receive compensation. Purchasers after section 4 notification have not been given the right to receive the higher compensation under the provisions contained in the 2013 Act. Again, 2000, para 19 is also the same. But please take note the last 4 or 5 lines of para 19. The sentence starting with we have come across. We have come across instances in which after notifications under section 4 were issued and the property was purchased at throwaway prices by the builders and unscrupulous persons, such purchases are void and confer no right to claim higher compensation under so and so. Then para 20. Given that the transaction of sale effected after section 4 notification is void, is ineffective to transfer the land, such incumbents cannot invoke the provisions of section 24, as the sale transaction did not clothe them with the title when the purchase was made. They cannot claim possession and challenge the acquisition as having lapsed under section 24 by questioning the legality or regularity of the proceedings of taking over possession under the 1894 Act. It would be unfair and profoundly unjust against the policy of the law to permit such a person to claim resettlement or claim the land back as envisaged under 2013 Act when he has not been deprived of his livelihood but is a purchaser under the void transaction, the outcome of exploitative tactics played upon poor farmers who are unable to defend themselves. Then para 21 are thus under the provisions of section 24 of the 2013 Act, challenge to acquisition proceedings of taking over of possession under the 1894 Act cannot be made based on a void transaction, nor a declaration can be sought under section 24 by the incumbents to obtain the land. The declaration that the acquisition has lapsed under the 2013 Act is to get the property back, whereas the transaction once void is always a void transaction and no title can be acquired in the land. As such, no such declaration can be sought. It would not be legal, just and equitable to give the land back to purchaser as land was not capable of being sold, which was in process of acquisition under the 1894 Act. The 2013 Act does not confer any right on a purchaser whose sale is void ab initio. Such void transactions are not validated by the 2013 Act. No rights are conferred by the provisions under the 2013 Act on such a purchaser as against the state. And the last paragraph is para 26. 23. I'm sorry, Millard, kindly have a look to Millard, para 20. Yes. Para 22 is important. Void is ab initio, a nullity, is inoperative, and the person cannot claim the land or declaration once no title has been conferred on him to claim the land should be given back to him. A person cannot enforce ripe fruits based on void transaction to start claiming title possession of the land by seeking a declaration under section 24. It will amount to conferment of benefit never contemplated by the law. The question is who can claim declaration rights under section 24 for restoration of land or lapse of acquisition. It cannot be by a person with no title on the land. The provisions of section 20 of the 2013 Act cannot be said to be enabling or authorizing a purchaser after section 4 to question proceeding are taken under the Act of 1894 of taking possession as held in UP Jal Nigam case. The Supreme Court is clear. Though this is under the 2013 Act, but still, Miller, the fundamental question is section 4 onwards. It is the previous owners who may have some right, but today, before your lordship, Miller, it's a subsequent purchaser. Now, the subsequent purchaser, Miller, has no right, Miller, after Miller, any in respect of transactions which have taken place, Miller, after section 4 notification. Well, my very respectful submission would be the same principles would also apply in case of Miller Act 2 of 1894, which has a two-phase acquisition. First requisition, then acquisition. Therefore, Miller, whatever are the principles which are applicable or the impediments and the fetters in respect of purchasers after section 4 notification under the Act 1 would similarly apply, Miller, in case of purchasers post section 4(1)(a) notice under Act 2. 26 তো আরেকটা জাজমেন্ট কে করে বলছে। But kindly also note down the paragraph 26 also it says the same thing. Just please note down the paragraph number only. But another decision which follows this is of recent origin. This is 2022 volume 10 Supreme Court cases, page 519. আমাকে একটা copy দাও।
Page?
দিয়ে দিচ্ছি আমারটা দেখে তো। Page 519, 2210 519.
Yes.
But 3 paragraphs only, paragraphs 12 to 14.
Paragraphs?
12 to 14.
Yes.
At the outset, it is required to be noted that from the counter filed on behalf of DDA, which is on record, it appears that the respondent number 1, the original writ petitioner, filed the writ petition and claimed the right, title, or interest in the lands in question on the basis of an agreement to sale dated 22nd of May 2016. As per the settled position of law, agreement to sale by itself does not confer any right, title, or interest. Even in the counter affidavit, the appellant doubted the genuineness of the transaction of the agreement to sale dated so and so. A specific plea was taken on behalf of DDA on the locus of the original writ petitioner. However, the High Court has not at all dealt with and or considered the issue with respect to the locus of the original writ petitioner. Be that as it may, even considering the fact that the agreement to sale was of the year 2016 and considering the fact that the notification under section 4 of the 1894 Act was issued on 25/11/1980, therefore, it is apparent that the original writ petitioner allegedly derived the interest in the lands in question much after the acquisition proceedings were initiated. And therefore, respondent number 1, the original writ petitioner can be said to be a subsequent purchaser. In the recent decision in Godfrey Phillips, after considering the other decisions on the right of the subsequent purchaser to claim lapse of acquisition proceedings, that is Meera Sahani versus so and M. Venkatesh, it is specifically observed and held that the subsequent purchaser has no right to claim lapse of acquisition proceeding. But this is very important. Similar view has been expressed by the larger bench in Shiv Kumar, the other one that I have cited today. Under the circumstances and even accepting the case on behalf of the original writ petitioner that she might have acquired some interest on the basis of the agreement to sale dated so and so, being a subsequent purchaser or having acquired the interest in the lands in question subsequently, she was not having any right to claim lapse of acquisition proceeding under section 24(2) of the Act. Under the circumstances, the High Court erred in entertaining the writ petition of so and so claiming lapse of acquisition proceeding. But this goes a step further that a subsequent purchaser cannot even claim lapse of proceeding. But all the arguments, Millard, were in this direction by a subsequent purchaser, in this proceeding before my lord. But these are my very respectful submissions. এই ফেরত দিতে বলছি, তুমি কিছু দাও না।
বলছি ও বলছে, তুমি তো বলছো না, আমি তো তোমার কাছ থেকে
ওর সম্পত্তি
Proceedings last 10 lakhs.
You are for 11 and 12?
I beg your pardon, Your Lordship. 11.
Only 11.
Only 11. Now, my lord, insofar as acquisition, requisition, and derequisition is concerned, my lord, that is something which is within the domain of the state to argue. I, as a private respondent, do not. But save and accept, my lord, what has been pleaded by the writ petitioner, and if there is any inconsistency therein, my lord, I am required, my lord, to point that out before your lordship. Now, that kindly takes up the writ petition once.
Yes.
I directly trouble your lordship with paragraph number 6 here at page 9 of the writ petition.
Yes.
Now, my lord, The consequence of the above transfers, the transfers inter se between the pro forma respondents and the writ petitioners. That consequence of above transfers, Renu Devi Chaudhary and her two sons, namely Pradeep Kumar Chaudhary, Praveen Kumar Chaudhary, being the pro forma respondents herein, became the absolute owners of a total of 46.50 decimal of Shali land equivalent to 28 kathas, 2 chitaks of land in RS Dag number 845, 846 and 847, all appertaining to RS Khotian number 178 under Pakuria Mouja. So, Malad, it's an admitted position that the case that the writ petitioners are running before your lordship pertains to Pakuria Mouja. Now, Malad, jail number 54 under Sholop 1, Gram Panchayat, PS Domju, District Howrah. Now, Malad, thereafter your lordship will find, take up paragraph 8, Malad, at page 10.
Yes.
That your petitioner states that a vast area of land within Mouja Pakuria, including the land, was requisitioned for West Howrah area development projects under the West Bengal Land Requisition and Acquisition Act 1948, Act 2 of 1948, at present expired, being LA case number 27 by 1 by AC by 11 CMDA of 1984-85. So, Malad, at all given point of time, it pertains to Pakuria. Thereafter, your lordship will kindly take up I wouldn't trouble your lordship with the other points, Malad. Thereafter, kindly takes up paragraph 18, Malad, of the writ petition. 18, Malad. Page 15, paragraph 18, the last paragraph.
Yes.
That in pursuance to the aforesaid order dated 15th February 2021 passed by this honorable court, Malad, the order passed by Malad Justice Amitabh Lala, as he then was, Malad, it has been pleaded in paragraph 16. By this court, the Deputy Secretary LA CMD under memo being number 116 LATS 14 PT 2001 dated 2nd February 2001, addressed to the Special Land Acquisition Officer, Howrah Improvement Trust, directing him to de-requisition, relinquish all the lands of the landowners requisitioned for the purpose of the West Howrah Area Development Project, and prepare the list of the said owners and forward the same to the Special Land Acquisition Officer, Howrah Improvement Trust, for doing the needful. Further, from a plain reading of the said memo, it appears that the said land was also made a part of the de-requisition, and the Special Land Acquisition Officer HIT was asked to take necessary action on the matter with intimation to the Deputy Secretary LA CMD. Malad, this particular document has been relied upon very strongly by the writ petition. Malad, that document appears at page 75, Malad, of the writ petition.
Yes.
Malad, this is the notice of de-requisition, Malad. Now, Malad, the entry number 4, Malad, therein, 75. Malad, there's a table, Malad. The entry number 4, your lordship will find Renu Devi Chaudhary. I've cited paragraph 6, Malad. That is how the writ petitioner claims their title. Renu Devi Chaudhary, RS Dag number 845 to 847. Now is the critical part, Malad. Mouja is Sholop and not Pakuria. The entry just before that, your lordship will find Krishna Devi Agarwal, 1304 to 1307, it's Pakuria. So there were, Malad, several plots of land which were de-requisitioned by way of this particular notice, the memo. So, Malad, in my case, Malad, these are the subject matter of dispute in this particular writ petition. Malad, the plots of land, RS Dag numbers 845 to 847 in Mouja Pakuria. Now, just, Malad, if your lordship kindly takes up the prayer portion in the writ petition, the prayers that have been sought for. Page 32 of the writ petition, Malad.
Yes.
A writ in the nature of mandamus commanding the respondent authorities, particularly the respondent number 7 herein, to issue formal order of derequisition in respect of the said land bearing RS dag numbers 845, measuring an area of about 33.50 decimals, RS dag number 846, measuring an area of about 4 decimals, and RS dag number 847, measuring an area of about 9 decimal, totaling to 46.5 decimal Shali land situated in Mouja, Pakuria. So, my lord, when the writ petitioners are seeking for a plot of land in respect of my property, which is RS dag numbers 845, 846, 847 in Pakuria, but the document relied upon by them in respect of derequisition relates to RS dag numbers 845, 846, and 847, but not in Pakuria, in Mouja Sholo. So perhaps this writ petition in itself is misconceived. They have placed their reliance time and again over this particular memo appearing at page 75 of the writ petition, my lord.
Yes.
So these are the dag numbers, my lord, which is specifically indicated that it refers to Sholo. The plot numbers which were derequisitioned by the state authorities, my lord, pertain to Mouja Sholo. RS dag numbers 845 to 847. And not in Mouja Pakuria, my lord, which has been conveyed in favor of the respondent number 11 by the Kolkata Metropolitan Development Authority. And my lord, in so far as I'm grateful to my learned senior friends as well, they have also, my lord, if your lordship kindly takes up the affidavit in opposition which has been filed by the KMDA, my lord, respondent numbers 3, 4, and 5, my lord. I'll directly take, yes. My lord, it's to the writ petition that I'm relying upon. My lord, perhaps this might be to the can. I'm not very sure, my lord, because it's a thinnish kind of an affidavit.
I think this is the one. By the KMD, yes.
Yes, my lord. Respondent numbers 3, 4, and 5, my lord. It's an affidavit, my lord, which was affirmed on. Just gives me a moment, my lord. My lord, it was affirmed on perhaps 13th or 19th, my lord, day of January 2023. Yes, yes. Now, my lord, in that particular document, my lord, I need not get into the details. It has been urged by Mr. Dotto, my lord, on several occasions. What I'm on, my lord, is page 26 of that particular affidavit, which is a report. It has also been placed by my learned senior friend. This is a report, my lord, pertaining to the award, my lord, which has been granted. That is, my lord, in respect of Pakuria. So the proceedings initiated, my lord, stands concluded insofar as Mouja Pakuria plot numbers 845, 846, and 847 is concerned. Your lordship will kindly take, my lord, the second paragraph. As per available office records, it is found on 20th October 2022 as follows. Total number of RS plot numbers under Mouja Pakuria, jail number such and such, involved in the LA case number such and such. I'll directly skip over, my lord, to the paragraph, the clause number 4, my lord, therein. Related RS plots of the said writ petition are 845, 846, and 847 under Mouja Pakuria, and also involved in LA case number 29/1, Act 2 of 1986-87. Now, my lord, this is the LA case which has not been relied upon by the writ petitioners. Their case is LA case 27. Whereas in the instant case, the award has been passed in respect of LA case number 29/1. Just to proceed there from, my lord, Clause A says name of awardee RS plot number 845 Krishna Devi Agarwal, total area acquired 0.33 acres, award declared amount 1,05,344 in favor of Krishna Devi Agarwal's. Award serial number 147, which was sent to the learned LAT court, Howrah, under section 30 of the LA Act, Vide check number such and such. So it exemplifies, my lord, that the payment had also been made. Now, my lord, to turn over, my lord, page number 27, clause B, small b, my lord.
Yes.
Names of awardees of RS plot numbers 846 and 847. Sorbeshwar Noshkar, Sotto Chandra Noshkar, Nitya Chandra Noshkar, both are the sons of Bongshi Chandra Noshkar, total acquired area 0.04 and 0.09 acre respectively. And my lord, thereunder also the award has been made. The payments also made, which would transpire, my lord, from the proceedings which has been indicated in this particular report also. So, my lord, my case is very clear. I have been conveyed 3 plots of land, RS plot numbers 845, 846 and 847 in Mouza Pakuri, wherein proceedings of acquisition has been initiated, and thereafter, my lord, it has also been concluded wherein the award has been passed. And, my lord, the document which my learned friends are relying upon, the writ petitioner, my lord, is at page 75, wherein those 3 RS plot numbers, my lord, pertains to Mouza Sholop and not that of Mouza Pakuri. So this is on facts, my lord, which I can very well distinguish, my lord. Insofar as laws, my lord, settled proposition of law, I believe all my learned senior friends have already made their respective submissions in relation there. My lord, I have also prepared, my lord, a notes of argument, which, my lord, I'll hand up on the next day, because I presume, my lord, Mr. Mukherjee will also make it rejoin in respect of the submissions made by the state authorities. Grateful.
Yes. Want to make your reply today?
Yes, my lord, on Wednesday, coming Wednesday, my lord, Mr. Mukherjee will reply, my lord. Today is some problem. Only thing is, I like to point your lordship at page 75. If your lordship kindly have a look at the note subject. Kindly have a look at the subject. Now he is
Page 75 of
trying
the-
to take advantage of the printing mistake, I must say, typographical error, because it's related to release of land from West Howrah Development Possession in Mouja, Khalia, Tetulkulia, Pakuria. There is no whisper of Salab. This is subject to these 3 Moujas only. And from the notification itself, your lordship will find that these plots, the Salab, there was any plot like this as of mine. So, my lord, I next Monday to Wednesday, my lord, we will do that.
My lord, so far, yes, he is relying on this.
Huh? I am no. I am not relying on this. My lord, what our specific case is this: after Justice Samanto's order, there was no acquisition proceeding. That is our only case, and this has been, my lord, categorically stated by the state that in due compliance of the order of Justice Pobi Samanto, they have initiated fresh proceeding. Although Mr. Sengupta categorically said the review, but their affidavit says otherwise. So without section 4, without section 6, they issued notice under section 9, 3 and 4, which is unheard of. Mr. Mukherjee will argue.
Well, if it be so, then perhaps my learned friend is not placing reliance on this particular document.
Our whole case is this, my lord.
If he does not, then there is no case of
order,
requisition.
entire acquisition proceedings lapse, taking into consideration the notification under section 4(1)(a), which has been indicated by the affidavit found by the KMDA in that earlier proceeding. And subsequent to that, no acquisition, no vesting. my lord, kindly take it up next Monday, Wednesday, my lord, at 3:30, my lord, Mr. Mukherjee will complete.
Councils for the KMDA and the 11th respondent. Paragraph. Let the matter appear on under the same heading for further consideration on.
Or subject to lawsuit convenient manner any day, my lord. Or next Monday, if your lordship so pleases, next Monday, kindly make it next Monday. Then other matter may be taken up on Wednesday. Huh?
11 should be convenient for all the.
11 মানে কি বার?
11 perhaps is Monday.
সোমবার 11. Mr. Mukherjee will answer
Give a reply,
on 11th 3:30.
or if you can come on 13th, then because I think we can conclude on the next day.
Yes, we will conclude. We will conclude.
So will you come back on 13th?
13th Mala 3:30. Yes.
For let the matter appear on 13th for under the same heading for further consideration on 13th, marked at 3:30.
Obliged to us.
Grateful.
Today, no one for the state.
Mr. Sengupta is not also was not there on the last day.
On the next occasion, you can.
At times, my lord, I get confused
Hearing
because
is not complete without him.
at times, my lord, I get confused
Analysis for the state respondents.
Grateful.
30.
$895.
My lord, I am appearing for the petitioner in this case.
My lord, I am appearing for SBSTC led by Mr. Arun Banerjee, my lord. My lord, I am appearing for not today, my lord.
My lord,
He has some
this
difficulty,
matter,
my lord.
your lordship knows possibly,
Affidavits are exchanged.
my lord, this matter more than a year. And nobody is appearing in spite of notice. Today they are asking for time. Very small matter, only section 3, nothing. We want compensation under 2039. All affidavits are complete. They have, the state government has relied upon the decision of Niladri Chatterjee's case. Your lordship knows there was a case under section 4(1)(a). Here there has been no 4(1)(a). Section 3, possession taken, handed over to SBSTC.
Nothing after that.
Nothing after that. I must admit, my lord, when this requisition proceeding was started, my lord, the requisition order was challenged, and order of status quo was passed. But ultimately, that order of status quo was vacated, and it has been admitted that all those documents have annexed. Thereafter, writ petition stood dismissed for default. Nothing is there, and not only that, in other cases which is covered by the same notification, my lord, notice now under section 3, my lord, direct purchase has been made. They moved the writ petition, contempt was filed, they have paid, but in our case, nothing has been done. Simply, we want that the compensation should be assessed under 2039.
State, who is appearing?
State, my lord, nobody is appearing.
Mr. Mondal was appearing.
Mr. Mandal was appearing along with the junior.
did the
I have served copies twice upon him. My lord.
None appears for the state respondents. Paragraph on prayer of the SBSTC, South Bengal State Transport Corporation. Comma, the matter is adjourned. Paragraph, let the matter appear under the same heading on 27th September.
27.
If you can please inform Mr. Mondal, only the date. Mr. Ansar Mondal is appearing.
3:30 to hobe na.
Yes.
My junior is asking for 3:30 because otherwise, more than a year. I have.
Come back, let me see, because 2017 matters always arrive at the top.
27.
It's an old matter.
Grateful to the Lord. 896.
Petitioner. Petitioner 896. You're appearing? Yes.
এই যে কি অর্ডারটা নিচ্ছেন এই যে 895 আমরা পেয়েছি এই যে ডেবিট তোমরা পেছনে লিখে রাখো 27 বলে 5 সেপ্টেম্বর
Affidavits are not exchanged.
One
The lordship directed the state to file opposition. But instead of filing opposition, we are praying leave to file one report. Because initially the order has been passed by this honorable court, there was a direction of paying cost of ₹25,000 with the special land acquisition officer. But on the last occasion, they have filed one affidavit saying that they have deposited the amount. But that amount has not been deposited, that I have specifically stated in my report. And
If that be so, that order stands. That was a conditional order. In default, the writ petition will be treated as dismissed.
yes,
Yes, where is your,
Your Lordship, I am leading by Mr. Shoptoshi Dotto. He is suffering from high fever, Your Lordship. I am not today. Your Lordship, kindly put this matter on any day, Your Lordship. We will
It's
come
a
with the
very serious
directions.
thing because they, by way of affidavit, they are.
let us not embarrass our junior friends.
Yes, no,
Come
I'm not pressing.
I am handing over a copy.
I'm not opposing her
Much
prayer.
obliged, Your
My lord,
Lordship.
now this situation has arisen.
Same submission made twice. You're ready for the hearing today. Where is the 25,000 payment?
That those sub, we have already paid.
Document?
Yes. In fact, I don't know why the submission is
The
being made.
state says it is not paid.
Am I handing over a copy of the report, my lord, that has not been handed over?
In fact, the erstwhile
The
advocate
primary issue that is being taken up.
has this, this affidavit is being
Take
given.
2 minutes and they make your submission.
Take
Take
this,
2
take-
minutes.
Where's the order? Yes. My lord, But
Mr. Butterman, you have a copy of the affidavit of compliance,
Yes.
page 6.
Yes, my lord. Please see it.
That's the demand draft.
Yes. Please, my lord, can you see my report, my lord? Report page, my lord.
where is your senior? কোথায় আছে?
13, my lord.
Yes?
Page 12 and 13 of my report.
Not traceable at the moment. There's a demand draft.
Thereafter, I can see page 13, my lord.
Confirm that.
This is not traceable.
Thereafter,
That is
Not
not the
traceable.
petitioner's fault.
Right.
but thereafter, can you see my page? Next
it-
page,
it-
my
it-
lord.
yes.
Page, my lord, 14. This is the register maintained by the special land acquisition officer. From the entire register, we, my lord, did not found, my lord, whether any, my lord, demand that has deposited with the, my lord, office or not, my lord. If any demand has deposited with the office, that has to be, my lord, recorded in this register, my lord.
Has
Look.
not been withdrawn.
It's not been withdrawn, yes.
And that has
We
not-
confirm that the draft, that means the draft was deposited. Please come to page 13. We confirm that the draft amounting to 25,000 in favor of the, that means the draft was deposited.
That's not been withdrawn by the special land acquisition officer, my lord.
That is your responsibility, sir. not
Correct.
the
That is
petitioner's.
page 14 and this is the register maintained by the special land acquisition officer, my lord. Officer, special land acquisition officer, page 14 onwards, my lord.
Show me the
Page
proof
15, my lord.
proof of payment.
Yes, what does this say? This register open on
The
such and
register,
such?
if any demand draft is deposited with the office of the respondent 3, they maintain this register. by-
Demand draft was deposited in your favor with the bank. The bank says, the bank confirms deposit of the demand draft.
But they have not deposited with the office of the respondent 3. That they have to, hand over the copy of the
Look,
demand.
may I hand up the original of the, where the receiving is there because it was sent
This
to
point
the
is-
learned advocate.
This point has been already
Yes.
decided.
Well, may I hand up the original with the photocopy of the demand draft?
Showing that is in doubt, man.
Is in doubt, it's sent to an advocate. If it's a communication gap between the advocate appearing for the state and then the petitioner can't be faulted with that. If today in the registry of the land department, there is no update, it's not updated, how can the petitioner be faulted with that? And today in 2023, when on the last occasion, affidavit direction was given, this stand is again being taken.
It's not very upon payment of cost, man.
So after your lordship was satisfied, the cost was paid. And in fact, there was no issue was raised on the earlier occasion. They did not say that we did not receive cost.
After receiving this compliance, we have made thorough searching.
The demand, is this part of your compliance report?
My lord,
Should have been? No?
I'll have to check, my lord, because this was the erstwhile advocate, my lord, had, because thereafter there has been a change of advocate on record.
It is, I think. Yes, page 5 of the compliance
Yes,
report.
that receipt is in doubt, my lord.
Receipt is in doubt.
See, they are showing in page 5.
That is your seal? You're doubting the seal also?
It is our seal, my lord.
It is the office of the collector land acquisition. Please, Mr. Watson, there is no further doubt. There cannot be any further doubt.
In fact, my lord, this is
Where is your affidavit in opposition?
Opposition have not filed because my lord, there is a direction of after payment of cost.
long back, 17 direction.
That has been settled on the earlier occasion. The affidavit of compliance was filed on the earlier occasion. That part is over.
After filing of their agreement compliance, we have made thorough search, my lord. And thereafter it is
So
found
if
that.
the office has misplaced it, the petitioner cannot be held responsible. You have received the demand draft, you have a seal. And if you doubt the seal, that's a criminal proceeding. You have not taken any steps.
It is not in the
The
register.
advocate has
We have not
received.
received the.
That is absolutely your problem, sir. The petitioner cannot be held responsible. Once you have received the demand draft, then it is, the ball is in your court.
We have not
In
received,
fact, my lord, it's a
But
demand
everybody-
draft. I have,
This is your seal on the document.
Doubt, my lord. This seal is not true.
What is in doubt?
At the seal.
Have you taken any steps against that if the seal is in doubt? You say it
what
is
is
forgery?
this?
You say it is forgery. What steps have you taken?
No step has been taken, my lord.
Please do not.
And
make
in
this
fact,
up.
In fact, my lord, this is a demand draft. It's equivalent to cash. I had to
Yes.
pay to the bank to get the demand. It's not a check. It's not
If
a
it is-
check.
If it
Why
is
would
not
I
an
not?
case, if they could not found it, then money will go back to the
No, money
petitioner.
doesn't, because I've already paid the money and purchased the demand draft.
If they
What
have
else?
not
Please,
encased,
They
it's not
have-
yours.
They have, no, the bank says the money has not been withdrawn.
Withdraw.
Bank
So it has
says
not
the
been
money has
encashed.
Not been withdrawn, meaning thereby that the money is deposited. A deposit is required in order to
Yes.
withdraw it,
Yes.
isn't it?
Money is deposited with the bank, my lord. And they have, my lord. whether
What
they
is the
have-
system of a demand draft, sir?
They have to deposit the money with the bank.
And then give you the demand draft?
Yes,
That
sir.
is exactly what is done.
Thereafter, they have, my lord, handed over the demand to the department or not, that is.
They have handed over, the department seal is there. You cannot deny that because you have not taken any steps against that. When was it received by you?
2017.
2017, we are in
2017,
2023.
and they have discussed it just last occasion, my lord.
Because thereafter
They have
nothing
filed, my lord,
happened.
Compliance report.
further,
The last occasion.
There's change of advocate. Earlier, erstwhile advocate should have done
When
it.
was the compliance report filed?
Last occasion, my lord.
In May. So from May to September, what step have you taken?
It is certain no step has been taken.
Then
So, my lord, the
Please
case
come
is
back with
pending.
your affidavit in opposition.
let this aspect be also inquired by them.
How much of
Doesn't
inquiry?
need to inquire
Because
anymore.
I am party to a proceeding.
How much of I think we should go into the merits of the matter. The authorities should go into the merits of the
Affidavit submitted on behalf of the third respondent is taken on record.
You need to.
Then, my lord, kindly adjourn the matter.
Payment of, no, adjournment is necessary. Come back with an affidavit in opposition.
Then we shall take raise step against them, my lord, whatever the appropriate step.
You have
But
not
because
taken
we are
steps
doubting page 5.
And then you will say at the incidence of the court, I'm
Yes.
taking necessary steps.
Yes.
That is not permissible.
If you are doubting him, take steps.
You are at liberty. Let this matter continue.
Yes. If the payment is not made with the,
Payment
there is a
is
direction of
made
this. honorable
according to the, I will record that payment is made. After
But
that,
we
if
have
you are
not
doubting,
received
you
the
can
ballot
take
money.
steps.
You have not encashed the demand draft. That's not the petitioner's fault.
It's your responsibility. Your
6
department has
years.
lost the draft. Petitioner has deposited the amount.
The change
With the
of
bank.
advocate
Or
can't.
we have not deposited. This is our case. We have specifically stated in my report.
You have lost the draft. You're blaming the petition.
The affidavit of compliance submitted by the petitioner
Who is
demonstrates
the hiring officer? Who has done?
payment of rupees 25,000 in terms of the order passed by a coordinate bench of this court. On 21st November 2017 was the order. On 21st November 2017, by way of a demand draft. Stop. Paragraph placing reliance on the report in the form of affidavit submitted by respondent number 3, learned counsel for the respondents submits that the draft has not been received
The report.
by his office. Paragraph. A letter issued by learned counsel for the petitioner, isn't it? Page, the letter issued on 24th November,
That's, my lord, by the advocate of the petition.
petitioner on 24th November 2017 indicates that the demand draft was deposited in the office of the collector, land acquisition department, South 24 Parganas. On 22nd November 2017, which is code by the receiving seal
November 8
of the department
24th to the
in
end.
the second page of the letter. Paragraph annexure A to the affidavit of compliance. Paragraph in view of the above, this court is inclined to hold that the order of the honorable, the order of the coordinate bench of this court passed on 21st November 2017 has been complied with by the petitioner. Paragraph petitioners.
Can you add one line? We are disputing page 5, to see which they are saying. We are disputing.
Have you disputed it in your report?
Yes,
At page?
report, my lord,
Have you disputed the seal in your report?
I have not specifically mentioned.
You cannot come up with new cases every time.
From the bar, a
Please show me
serious
one.
allegation is being made.
Yes, specifically stated that the payment has not been made.
I have recorded that.
A serious allegation is being made from the bar without being recorded in the affidavit.
তোমরা এফিডেভিট থেকে ফাইল করছো? This is the affidavit.
Paragraph. Affidavits are yet to be exchanged. Paragraph. Affidavit in opposition be filed by the respondents.
না না
Within 2 weeks.
In fact, my lord, on earlier occasion, the status report filed by the state, everything has been disclosed. But the honorable court desired that this should be filed on affidavit. That is why the state was specifically directed to file all these documents by way of an affidavit.
And only an affidavit was called for from the state, not the
From
KMD.
Not the KMD.
in my State status respondents report,
we have also disclosed about everything has
I have,
been.
I have filed a supplementary, I filed a supplementary affidavit. If the state wants to use an affidavit to that, let the state file a
Can we disclose on the basis of this report also, my lord?
on state. I have filed a supplementary affidavit thereafter.
No, supplementary affidavit, they have filed earlier, one supplementary
Yes,
affidavit was
subsequently I
filed.
filed a supplement.
Subsequently,
The motion stages.
at the motions and without the leave.
There was earlier a direction
No,
for
leave was-
affidavits. If today the state says that they don't want to use an affidavit,
No,
my lord
the
will,
direction for affidavits was only on this count.
my lord, on the 16th May 2023 order, my lord will kindly seize affidavit in opposition to be filed by the state respondents in terms of the order passed of 21st November 27 within 3 weeks after summer vacation, and affidavit in reply filed within a week thereafter. So if the state says that they don't want to use an affidavit to, let them make that statement.
On the basis of the report in the form of affidavit. No, don't do that, don't do that. When there is a direction, my lord.
I don't know why KMG in
Because our interest.
if he doesn't want to, if any party doesn't want to.
How the requiring body cannot be involved here.
But then you are saying you're not filing an affidavit.
Affidavit in opposition be filed within 2 weeks from date. Stop affidavit and reply, if any be filed within a week thereafter. Paragraph, let the matter appear in the monthly list of November.
Grateful,
November,
grateful, my lord, deeply obliged.
under the same. E-code. E-C-H-O-E-D. E-code. E-code.
Only one line, my lord.
মানে পরে বলবো।
If any forgery is detected, whether authority will have a.
How is he making this submission? Law gives
always-
you the liberty. This court, writ court will not grant you liberty.
His report doesn't say
It
so.
cannot grant you liberty to file a criminal complaint, isn't it? Next.
$897.
My lord, I am for the petitioner, my lord. In this matter, my lord, your lordship may remember, my lord, Viran Chandra Bhattacharya, senior advocate, my lord, argued the matter at length, my lord. All papers are ready, my lord. But my lord, in change of my lord, lawyers, my lord, of state, my lord, we have served again, my lord, all the copies to my state respondents, my lord. Kindly, happy to have service, my lord. Kindly.
Who is appearing, Mr. Bhattacharya?
Yes, we are appearing,
All-
my lord, but
And when the matter is covered by Vidya Devi Judge, my lord, your lordship.
Yes.
my lord, we have not received the copy of the opposition and reply. Only for a copy of the reply is received from the office of the government leader, my lord. To whom he has served, I do not-
Mr. Masood,
he is not, এখন আর নেই উনি।
Masood আগে ছিল।
He is the previous learned
No,
advocate.
no, these are not.
All the copies.
My lord, after change, first I have served, then my lord again change, then change, but then in July 2023, we have served. Kindly see, my lord.
Served copy of the writ petition. Have
Read
you?
petition along with all my lord, affidavits, my lord, affidavit in opposition, filed by respondent, affidavit and file of petitioner, written notes of argument, all everything, my lord. We have served up in the state, my lord.
Why
Again,
don't
my
you-
lord.
Why don't you hand over us another copy?
Then,
to
then,
me?
my, then, my, and not now, my lord.
Not equipped
And
with
then
the-
I'm what am I submitting, my lord, kindly fix a date, my lord. My lord, lady, my lord, very poor lady.
I am fixing a date. Please serve the copies in the.
Is
matter.
my lord, day after tomorrow, my lord.
This court has a lot of matters.
Copies, the day after tomorrow, copy will start, my lord. But any day, my 3:30, my lord, lady, my lord, very poor lady, my lord, and my lord, she took the land, my lord, without recourse, to law, my lord.
Naam record করুন। The matter is adjourned.
So,
Paragraph, let the matter appear under the same heading on 25th.
20. My lord, kindly, my 3:30, my lord, my matter is top of the list, my lord, then top of the list, my lord.
Next one.
Kindly consider, two of the list, my lord. Top of the list, my lord.
It
Kindly
is
consider,
top of the list, sir.
kindly consider, my lord.
It is appearing at
Is
the
my time, my lord.
2017 matter will generally appear at the.
25th. Yes, my lord. And the matter is covered, my lord. Vidya Devi Judge, my lord. Your lordship knows, my lord. Yes, my lord. Yes, my lord. I've
Next
also.
matter.
98.
3 times, my lord.
898, my lord, I am for the petitioner. I pray for 1 week's adjournment.
Who is appearing for the state?
I don't know actually. Nobody's.
Mr. Sengupta was appearing. There's a change in the panel. You have to serve a fresh notice.
Kindly adjourn for 1 week.
You have to serve the state.
In the meantime, I shall serve.
None appears for the state respondents. Paragraph, since there has been a change of learned counsels in the state panel, comma, the petitioner is directed to serve afresh. Anyone for the petition?
Fine, my lord. We had started, my lord, making our submissions. This is in respect. However, my lord, some handicap today. I don't have instructions, proper instructions, my lord.
The respondents are not appearing.
Respondent, Mr. Choyan Gupta had appeared.
And what about the state?
My lord, the state respondents, state possibly.
Not find the state being represented.
Yes.
Only Mr. Gupta was there.
Yes, my lord. Will
For
you
the
remind,
HITCO, isn't it?
my lord,
For the HITCO.
Hitco, yes.
Should be someone for the state.
Yes, there should be, my lord. Will it be my lord's pleasure to adjourn the matter for a week? My lord, I'll also take instructions because I'm briefed in the matter. I was briefed in the matter, but then some possibly
I think you have to serve the state afresh because
very.
state is not-
We'll give the notice to all the respondents. State has also Hitco because they're not there.
None appears for the respondents. Paragraph, let the matter appear under the same heading on 4th October.
4th October, madam.
Paragraph, the petitioners are directed to serve notice upon the respondents, intimating the adjourned date.
Grateful.
2017 matter, the cause of action still is alive.
My lord, last occasion it was alive, my lord. I was.
It's fine.
900.
My lord, I appear for the KMD in this matter.
Petitioner? Go on.
Petitioner is Mr. Chandi Charan Deis for the state. Highly contentious matter here. The various.
None appears on the earlier date also no one appeared. Dismissed for default. Rajiv. None appears for the petitioner and the state respondents. No accommodation is sought. Dismissed for default.
Much obliged.
So highly contentious that the petitioner doesn't appear at all.
The matter was, well, at 901, I am for the petitioner.
Yes.
I am for the KMD. Well, the matter in short, I don't think I will be able to complete today. So Mr. Dey is for the state. Mr. Dey's role is very important here.
So let me just record that the state is not there and party.
In fact, he is seeking to enforce an order passed by the civil court.
No, not really. Not really. My lord, the point is very simple, my lord. I am the petitioner. I had two properties. Now in one property, acquisition completed and I got the compensation. Now, my lord, in the other property, in respect of that, my lord, although acquisition order has been passed, there has been enhancement. I went to court. But my lord, from last 40-50 years, I did not receive a single penny of the enhanced amount. And when and file this writ petition, my lord, on the point of Pune Development Authority, that if the compensation is not paid, then my lord, I am supposed to get at the present market value. When I find the writ petition, they came up with the order that see this amount, you are ready, you can take. So this is the situation. It's not, my lord, simple thing. The point is, my thing is, my lord, acquisition has lapsed and I am entitled to, my lord, the compensation in the present.
He has made it complicated.
Position taken.
He has made it complicated.
No, I say position taken, but well, there are 3-4 grounds under the new act of acquisition. That well, the position has not been done. And second is well, the amount is not paid.
It's either.
So I did not get the amount. So that is my question. And in spite of the order of the
Come back.
yes,
He doesn't come in any way.
okay.
Accepted the collector's award. He was dissatisfied. Reference made. Amount enhanced. That was not executed for years. When he could not go before the civil court, he came to the writ court to enforce it. Now the 2013 Act came in the meantime. Now he is seeking the benefit of 20.
That is your case.
None
Lordship
appears-
has to see.
None appears for the state respondents. Let the matter appear under the same heading. On 4th October.
4th October. Lordship, I'm ready.
This is not the mentioning time, sir. I'm sorry. This is not the mentioning time. I cannot hear your submission now. Come back at the normal when the mentioning times are taken up.